The public panel interview of the candidates for the position of Good morning, Your Honors. Today is the start of the public panel interview of the candidates for the position of Supreme Court Associate Justice, Vice Honorable Associate Justice Mario V. Lopez, who will compulsorily retire on June 4, 2025. Please all stand for the national anthem, the centennial prayer for the courts, and the Supreme Court hymn.
Mga kababayan, ang pambansang awit ng Pilipinas. Kayang magiging helos ng sinakanan, alam ng puso, sa dibdib mo'y buhay. Lupang hinirang, kuya ka ng magiting, sa mandulupin, di ka pasisigil, sa nagataputok sa simoy at sa langit ng pagaw, ay hinatang tulakawin sa pagkayang minamahal. Ang isang matawad mo'y tagumpay na nagkikinig, ang bituin at araw niya kailan ang ay di magkikinig. Lumalang araw ng walhagin pansin ka, buhay langit sa piling mo. Ang higaya ng pagkay mga amin, ang mamatay ng dahil sa'yo.
Greater glory. Amen. Allow me to introduce to you the members of the Judicial and Bar Council who are present in this morning's public panel interview. We have the Honorable Justice Jose Catral Mendoza, JBC Executive Committee Chairperson and regular member representing the retired justices of the Supreme Court. Honorable Attorney Nesauro H. Firme, regular member representing the Academe, and Honorable Justice Arlinda Piñera Uy, regular member representing the Integrated Bar of the Philippines. May I now refer you to the Honorable Justice Jose Catral Mendoza to officially open this public panel interview.
The public panel interview of the candidates for this position, vacant position of Associate Justice Supreme Court is hereby open.
Your Honors, the candidates to be interviewed this morning are Honorable Court of Appeals Associate Justice Nina Antonio Valenzuela, Honorable Court of Appeals Associate Justice Ramon Bato Jr., and University of the Philippines College of Law Dean Darlene Marie Berberabe. May we request the candidates to please stand up and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview of the JBC? So help you God. Thank you. May we request Justice Antonio Valenzuela to please take your seat in the middle, and Justice Bato and Dean Berberabe to please proceed first to the holding area. Thank you po. Your Honors, the first candidate to be interviewed this morning is the Honorable Court of Appeals Associate Justice Nina G. Antonio Valenzuela. The first to interview Justice Antonio Valenzuela is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good morning, Justice Antonio Valenzuela. Welcome back.
Good morning, Your Honor. Thank you.
You have previously applied for the Supreme Court.
Yes, Your Honor.
With your 15 years of experience in the Court of Appeals, 5 years in the RTC, 4 years in the MTC, can you share a significant case or legal decision that had a profound impact on you, and why is this so?
Well, aside from my years in the judiciary, I also was a Supreme Court legal researcher, and then also court attorney 5 at the Court of Appeals with Justice Guerrero. So all in all, I've been in the court for running my 35th year in the judiciary, and 15 years in the Court of Appeals. The question is with respect to
Significant decision
in the
that had a that has a significant impact on you,
in the
which
Court
you
of
rendered
Appeals.
any.
All right.
It's a
Yes.
long way back, I know.
Yes, I know. Yes, Your Honor. The one that had most impact for me was when I was in the regional trial court. It was the case of the rural banks. It was my first experience on how media can. Media is so powerful, and it caused me a bit of some stress because it was after
What is this case again?
the rural banks case.
A rural bank. So it's a civil case?
They were asking for a temporary restraining order to restrain the banks from allegedly closing the rural banks.
Oh.
The case reached the Supreme Court.
And you were affirmed?
I was affirmed by the Court of Appeals, but not the Supreme Court. So the Court of Appeals was also set aside. The Court of Appeals decision was also set aside. Anyway, Your Honor, that was my first experience as to how the public social media can react to certain decisions. I from the beginning up to now, I try to shield my work from the public, i.e., I let just the PIO and whatever concerned office speak and I maintain my silence. However, in that case, it was multimedia. They were disparages over the radio, over the newspapers, etc. And there were no the legal issues were not even discussed. So
In your years in the judiciary, have you encountered any challenging ethical dilemma? And how did you resolve it?
when I was in the lower courts, there were no pressures like that, no ethical dilemmas for me. I would like to say I've maintained my stance that I be square and stick to the rules. And I'm proud of that. But however, in the appellate court, I guess things change. So there was pressure already, and I
Pressure from whom?
all sorts. I guess that's what the cases are more important, and so there would be pressure from the media also, and some maybe your colleagues even asking you, etc. And of course,
How did you handle that?
I always
Pressure from your colleagues.
I always say, first, I apologize. I hope you understand. I'm sorry. These are the things that we have to do, and I should not be apologetic. However, to maintain harmony with my colleagues, I will apologize and say I will study the case, and I hope you understand that there are facts, there is the law, and there's the duty. And I am happy to say that my colleagues are always accepting of that fact.
It appears that you are a director of the Federación Internacional de Abogadas. Can you describe your role or functions as a director?
The FIDA now is we hardly meet anymore. Before, it was very active. Nowadays, it's not anymore.
Oh, okay. I see. What would be your significant achievements and experiences which you feel highly qualifies you for the appointment to the Supreme Court?
Well, my 35 years, Your Honor, in work in the judiciary would speak of my competence and diligence, as well as my integrity. So the Supreme Court keeps track of our. We have statistics for the work that we do. So far, for the last 5 years, I had a 2% reversal rate. It actually increased. It used to be 1 point something. And I checked the records. It was the reversals were criminal cases. We were guessing that it was because of the drugs cases. So it's just it's 2% for me is now high. It used to be 1 point
1%.
something.
And you're aiming for 0%.
Yes, and then my output is yes. When I was in the lower court, my outputs were 1, so it meant that the numbers for the raffle to me and the numbers decided were equal. So I would not have any backlog. Up to the present,
now.
more not very much because I understand. Also, I forgive myself because the cases are harder and they're more they require more study.
In your PDS, it is shown that you voluntarily inhibited in a case only once in the entire years that you are with the judiciary. Is that so?
Yes, Your Honor. But I cannot remember which case that was. But yes, because to me it's a duty.
Is it based on relationship or what
I-
was the ground?
I think that was voluntary.
In your
Um,
years with the CA or
with the CA. But
see.
before, in the lower courts, everything was voluntary as well. And in the lower courts, I observed the counsel and the litigants would always move for inhibition in case they didn't like you. And so um, if they moved for inhibition, and I read there were many, and every time they moved for inhibition, and if there was a ground, whether it would be voluntary or mandatory, I would allow it. But in the Court of Appeals, there's hardly any, just that one.
And what was the ground?
I think it was voluntary because they were insinuating that I had ruled in their disfavor.
Prejudgment?
Had ruled in an interlocutory.
Okay.
If I remember correctly, Your Honor.
In your opinion, should a member of the bench lean more towards judicial activism or judicial restraint?
A member of the bench leaning on a certain judicial philosophy would be leaning towards a specific legal philosophy would not be practical to do. It would be more judicious to take it on a case-to-case basis. For instance, it depends on the issue. If the issue is something that is novel, for instance, then maybe we could take the ground of a judicial activism. However, if it's like review of just a judicial review of lower court's decisions, then I would be prone to take the judicial restraint path.
Under Section 5, Paragraph 5, Subparagraph 5 of Article 8 of the Constitution, the Supreme Court has the power to promulgate rules concerning the protection and enforcement of constitutional rights. Can you name some significant rules promulgated by the Supreme Court for the protection of constitutional rights?
There's a rule on the writ of amparo, the rule on the writ of kalikasan. What else?
One more.
I can't remember anymore. One more.
Can you describe what these writs are?
The writ of kalikasan is there's a constitutional the Constitution protects the rights of the people to a healthy environment, and so the writ of kalikasan is available in case there are parties who seek in case a party's right to a healthy environment is violated, then there is the writ of kalikasan to give redress to that particular grievance, and the court can issue the writ to compel a specific action from the respondents.
What about the writ of amparo?
The writ of amparo is for it's against right to liberty. Yes, and so if there's a violation of the right to liberty, the writ of amparo would be available.
One more writ.
Writ of amparo.
Habeas data.
Habeas data, yes. There's also a constitutional right for privacy, and in case there is an intrusion on the right to privacy, the party can invoke their right to the issuance of a writ of habeas data.
What is the legal remedy available to a person who has been wrongfully deprived of a liberty due to mistaken identity?
Mistaken identity available is the writ of habeas corpus. Yes, Your
Right.
Honor.
Would you be familiar with the doctrine of an available child? And what is the essence of this doctrine?
Unavailable,
Spent by our retiring Justice Lopez.
unavailable child.
An available child doctrine.
I'm sorry.
This involves cases of child abuse. It's a decision penned October 25, 2023.
I'm
You've
sorry,
not-
Your Honor.
You have not
I'm not
read.
familiar with the doctrine.
Okay. Um, I'll cite the case. The Department of Science and Technology, or the DOST, in line with the Build program of the government, filed a complaint for expropriation to acquire 1,200 hectares of land owned by a private person to construct a state-of-the-art weather forecast center in Batanes. The court granted the expropriation, fixed the amount of just compensation, and installed the government in full possession of the property. If the government delays in the payment of just compensation, can the owner demand for the recovery of possession of the property? And please explain.
This matter concerns the state's power of eminent domain. A petition for eminent domain, when filed, it is ministerial on the after when the allegations show that there is a public purpose and there's a valid public purpose and there's an ordinance that or a particular document that allows the expropriation, then the court would allow would issue an order requiring the payment of bond in the land bank, and then it issues a writ of possession. Then after that, the court will receive the answers or oppositions to the writ, to the petition for expropriation, and the court shall do a hearing. But essentially, because it's the government that wishes to become owner of the land for the public purpose that it was intended, the government the state already takes possession, actual possession. In the meantime, there is already that deposit, and then the court will make a determination of the actual compensation due to the party whose property was taken. And so if the court has already ruled on the amount of compensation, the just compensation, and the government does not wish or refuses to pay, the aggrieved party can move for execution, i.e. also move that the bond already deposited initially be released to them, and then
In addition, what right does the owner have for when the government delays in the payment of just compensation?
essentially the owner of the
Can you please answer whether the owner can demand for the recovery of the possession of the property?
No.
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 So what's the right of the property owner?
if the court for sure the court
Can demand the owner
the court
can demand.
already issued a ruling with respect to just compensation, then it is a
Yes.
matter of executing it.
So it's only just compensation, no additional right granted to the property
By-
owner?
just
Anyway,
compensation.
interest.
Oh, plus interest, of course.
Yes.
Yes, Your Honor.
One last question. Under what exceptional circumstances may the writ of habeas corpus be availed of as a post-conviction remedy?
Post. Writ of habeas corpus is only available in case the detention is illegal. So,
What else? That's one.
and then if the authority, if the person detaining is without authority,
Okay, one more.
and that's all I can remember, Your Honor.
The imposed penalty is excessive. So that's my last question, Justice Valenzuela. Good luck to you.
Thank you, Your Honor.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nezauro H. Firme.
Thank you, Attorney Cuevas. Good morning, Justice.
Good
Sorry.
morning, Your Honor.
So, how did you prepare for today's interview?
I relaxed.
Yeah. So, I understand that you applied previously to become an Associate Justice of the Supreme Court.
Yes, Your
How
Honor.
many times,
I
Justice?
cannot remember because I applied to be associate justice and applied to be presiding justice
Okay.
in the CA. So I cannot remember which.
Were you
time.
shortlisted during that application to become an Associate Justice of the Supreme Court?
Never.
Okay, so if appointed Justice, what would the stakeholders expect from you?
The stakeholders can expect from me to continue what I have been doing for the last 35 years in my service to the judiciary. So that will be honesty, integrity, probity, independence, and competence. Yes, diligence, yes, and hard work all the time.
Okay. So in your application letter, Justice, you mentioned that you are intelligent, diligent, industrious, and patient, in possession of judicial temperament and impeccable honesty and uprightness. Can you think of some areas in your qualification that you still need to improve on so you can be a better version of yourself?
I want to work faster. I'm very meticulous, so it takes a while. Each decision is gone through several times, and maybe sometimes I overdo it. So maybe I should make myself limit the number of times so that the output will be faster. But of course, the decision should be correct and the quality should not suffer.
Based on your PDS Justice, you took the bar 2 times. Can you tell us the circumstances during your first take and what adjustments have you made in order to make it on your second try?
Your Honor, yes. Every time I apply, this is asked. My friend, when I first applied to join the judiciary, he asked me, I know you very well. You're competent, honest, etc. You have no flack and you will not have any, I know, except this. Are you ready? I said, oh yes, I am ready. So it makes me nervous when I say this, but yes, I am ready. And of course, I'm not incompetent, neither am I dull. I thought I was very bright. My IQ is not low. So I figured where was the glitch when I flunked. When I took the bar the first time, my family was fully supportive. I had no quarreling parents. I had no financial problem. I had no problem at all. So where was the glitch? So I'm not dumb. I had no boyfriend who was horrible. My love life was perfect. My family life was perfect. Everything was perfect. And so where was the glitch? I figured I did not study in law school. So from then on, I took it upon myself to work really hard. In my youth, I would like everything was I just everything was taken like a breeze. I just go through things and I'd pass, and I was happy-go-lucky. I had parties, I had love life. So everything was smooth sailing until I flunked the bar. And the stigma that comes with it is should not be experienced by others.
Also, based on your PDS Justice, 407 of your Court of Appeals decision have been appealed. Do you know how many times your decisions have been reversed or modified by the Supreme Court? Actually, it's in relation to the question asked earlier by Justice Uy. So, in relation to that, do you think, or were there instances you believe that these decisions, the Supreme Court, in reversing you or modifying you, is somehow erroneous? That your decision in the CA is a more correct version?
I cannot say that my decisions were more correct. The which I checked the reversals, they were all for criminal cases, and there were 4 of them out of the 400. So it's like 2%, which is, as I said earlier, a bit high for me. But I think I'm recalling that there's probably some policy that that has changed in the Supreme Court, because we noticed that where I was reversed, I was following the jurisprudence that was strict, but then I think it was during the time of the President Duterte. I think there's now a lull in that, and so they're more the justices are not as strict anymore. Hence, the 4 decisions where I was reversed. I'm just guessing because yes,
More on justice drugs cases.
the
penalty
criminal
imposed,
cases.
yeah.
Yes,
Penalty
Your
imposed or acquittal.
acquittal. Yes, Your Honor.
Yeah.
The-
In 2011,
they were acquitted.
Yeah, okay, sorry. In 2011, Justice, the Court of Appeals, through your decision, affirmed the ruling of a lower court finding former Bombo Radio anchor guilty of libel. So now the question would be, in cases of blind item, so under what circumstances can a writer or author be held liable for the libel? For instance,
How can-
blind item, I did not specifically name the person, the subject. Under what circumstances can I, as an author, as a writer, can be held liable for libel?
The author can be held liable for libel even if the particular name of the target is not mentioned. If there are descriptions or in the writing that would pinpoint to that person, then that would be yes. If it is so specific that you can identify the person of which the writing speaks of, then the author could be held liable.
Also, Justice, actually, this is in relation to one of the decisions you penned. No? So under Article 2230 of the Civil Code, exemplary damages may be granted if at least one aggravating circumstance attended the commission of the crime. Now the question is, should this aggravating circumstance be specifically alleged in the information in order for exemplary damages to be awarded? Do you remember that case decided by you before the...
Exemplary damages are awarded to for the purpose of the public, so that the public will not repeat the same act again.
The question actually, Justice, is this. No? We all know that the Civil Code states that in order for exemplary damages to be awarded, there must be the presence of aggravating circumstance. So, is it necessary that this aggravating circumstance be specifically alleged in the information so that you, as the magistrate, would award the victim with exemplary damages?
The information should indicate the aggravating circumstances, and then also the evidence should also prove the aggravating circumstances, so that the court could validly grant an award for exemplary.
So otherwise, Justice, if it is not alleged, you would not award exemplary damages to the victim.
Yes, Your Honor. Yes.
Earlier also, I don't know if this is the case you're referring to about the rural bank.
Yes, Your Honor.
In relation to that, no, the Supreme Court made mention of this doctrine, the close now, hear later doctrine. You were also the judge at that time. So do you think this is constitutional? Would it not violate the due process of law? Because you would close the bank even before hearing their side.
According to the Supreme Court, it had that power to close the bank before hearing because financial institutions are important in the Philippine economy, and so it was trying to protect the economy, financial institutions. However, I would like to point out, and this was not written in the decision of this Supreme Court, I issued a TRO because we conducted a hearing. I issued an injunction because after at the hearing, I asked if because I wanted to know one of the I was checking on the requisites for the issuance under Rule 58, and as I was conducting the hearing, there was a person. He walked. We were in the courtroom, and he walked. He barged into the hearing, and he was shouting, "I am from the central bank, and we are closing the banks right now." And so there was the last requisite that I was waiting for, the imminence of it, he answered. And so I had no choice in the exercise of my discretion. All the requisites were present. He just out of the blue said that they were going to close the banks. I remember I was at the time listening to the testimony of the officer from the central bank, and the person who barged in was a lawyer of the central bank. So, yes.
So you think that is a valid exercise, the closed now, hear later policy?
We have to weigh the interests.
Yeah, because there are two conflicting
Yes, the
rights
interest
here.
of the financial aspect of it, and then the interest of the bank itself. So I would agree with the Supreme Court that there would be a bigger, more important interest than a single bank if it was for the economy. Hence the necessity of that doctrine.
So if there is an equipoise, you will tilt the scales of justice in favor of the public interest
Yes, Your Honor.
over the alleged lack
Right.
of due process
Of
on
the
the part
bank.
of the bank.
Anyway, after they are closed, they're not if I remember correctly, they are not forever closed. The central bank has certain procedure which can review whether or not they could operate again. So it is not a total stop on the operation of the bank.
So this is actually in relation to your with regarding to seniority in the Court of Appeals. Remember that one? So at present, the JBC is interviewing two applications for the position of Associate Justice of the Sandigan Bayan and two vacancies for the associate to become the Associate Justice of the Court of Appeals. So the question is, how would you determine the seniority between those two appointed associate justices?
Well, seniority has a particular meaning in the internal rules. However, if I were the JBC and
No, I mean, if for the for purposes of you are already appointed by the president, so how would you determine who is more senior over the other?
that's my case again, Your Honor. Yes. In the case, when I was appointed in the Court of Appeals, there were four of us appointed. My the ruling was I was the most junior. However, I had the highest sticker. So, in other words, if you take it by that the palace releases appointments and sticking the stickers, attaching stickers, mine was the lowest number. Therefore, I should have been the one that got appointed first and got signed first. But the ruling was not that way, but it was pro hac vice. So it broke my heart, but it was pro hac vice.
Well, would the taking of oath matter? Because if you
We took our
remember,
oaths all together, all four of us.
actually, this is a case. No, for instance, you took your oath, no, before different justices or probably any authorized officer to administer oath. The one with the lowest, what do you call that? Sticker number, the barcode number, took his or her oath first. Do you think would it matter?
The law speaks of an appointment. An appointment is valid when it is the moment it is released. In other words, if the appointing authority signs but keeps the document in his drawer, does not release it, there is no appointment. So, upon the release of the appointment, then the appointment it becomes valid. Receipt, the acceptance as well of the appointment, and then taking the oath. So,
Because if you recall in the Garfield doctrine, diba?
yes,
Three
yes.
things must concur: the
Yes.
appointment, the taking of oath, and the assumption of
Yes,
office.
but in MECAM, I think it's only, well, it's the signing and the release. Because if the appointing authority signs but declines or forgets even to take out the paper, then there's no appointment. But yes, there are three. But in our case, we took we took our oaths all together. We stood up and we took our oaths at the same time before Chief Justice Corona.
So another case, no. For instance, the police officers, they are respondent in a petition for writ of amparo, and there is also a related criminal case. Now, they invoke that the amparo petition would violate their right against self-incrimination, no? Because they will be telling something that would prejudice them in the related criminal case. Is that a valid argument?
The writ of amparo is only available for extrajudicial killings, and so in this case, I did not The facts of the case do not indicate that this is, it's just an ordinary criminal action, sir.
For instance, there is a related murder case for the the ground for the issuance of the amparo is enforce extrajudicial killings.
Oh, there, extrajudicial killings.
So
Yes,
that is
Your
the
Honor.
ground for the issuance. So
Yes,
they
yes,
do
Your
not
Honor.
want to tell something. No? In that rate of amparo, they do not even want to comply or give the return simply because it would prejudice their rights in the related extrajudicial killing case, murder case.
The writ of amparo would be available. Again, we have to weigh the interests of the two adverse parties. The policeman can explain the validity of their detention of the persons, as again to cure the purpose of the writ of amparo, which is to protect against extrajudicial killings.
So next question, Justice, what aspect of the SPJI, you're familiar with the SPJI, do you want to get yourself involved in, and what programs do you want to improve, if not institutionalize?
Well, for one thing, the technology development, it's very crucial, especially because the court has a target of a paperless court, and so the court should make a push. I know it is already doing it. If I were appointed, I would make a push for the improvement of the facilities, the Wi-Fi. As a matter of fact, our Wi-Fi in the Court of Appeals is very spotty, so we have a little problem with the email pleadings coming in. In fact, the other day we had a big problem. Our DCC had to go to the office at 9 o'clock. It was an election case, so the Wi-Fi is spotty, and also another thing that should be pushed is for the infrastructure, the buildings, the structures. I'm very happy that the Hall of Justice for Manila would, I read, would be pushing through already. I was MTC in Manila in 2000. Up to now, it's 2025. It has no Hall of Justice. Justice Uy knows that. I took over her office so it would be so welcome if the Manila had its own Hall of Justice. After all, it's the premier city, and Justice Uy had to remodel and use her own funds because it's not, yes.
Last question for you, Justice. No? So one of the barometers for global competitiveness is the Rule of Law Index. So adherence to the principles of good governance is one key to improve the country's standing. So what are your concrete plans, particularly involving the principle of equity and inclusiveness to attain this objective?
I'm sorry, inclusiveness?
Equity and inclusiveness. So what are your concrete plans, no? Particularly focusing on this principle of equity and inclusiveness so that we will be able to attain, no, or probably elevate our standing
Good mark, yes.
in this Rule of Law Index.
I was the chair of the policy of the Supreme Court with respect to SOGSC, and it was a very the project. We already drafted the project for SOGSC, so it would be it's now pending Actually, it's on the wing right now, on the wings right now. So this would give us a high score on inclusivity and equal protection. So we will, well, already the court has already done the Safe Spaces Act and gender fair language, but this would be a very important document because it's the first in Asia.
Justice, how will it be different from that, from the initiatives which are already present with the Supreme Court?
The way we were doing it, this is the general policy for the entire judiciary, and so all these things, all the memoranda and other rulings like gender fair language and court etiquette, etc., will be under this general policy. So it will be covering from the MTC to all the trial courts up to the Supreme Court, and will cover also employees, litigants, and judges and justices. So that, yes, it would be, I think only Northern Europe has it, has such a policy for courts. So we will be the first in Asia. And it is, yes, it's in the wings. It's already prepared. We started doing this during the pandemic. It was Justice Leonens who initiated it. It's a wonderful project. I'm very proud of.
Thank you, Justice. That will be all, and good luck.
Thank you, sir.
Thank you, Attorney Firme. Our next interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marife Cuevas. Good morning, Justice.
Good morning, Your Honor.
I had extensively asked you several questions before. I even covered your oblation run as a member of ETA
Yes, Your Honor.
chapter of the APO.
Yes, Your
But I
Honor.
will not cover them anymore.
Yes, Your
I
Honor.
represent the retired justices of the Supreme Court.
Yes, Your Honor.
So my initial questions will be from them. Okay, some of the questions were already covered by your answer, but you can elaborate further if you want to. Okay, from Justice Ascuna, you have answered this, you have covered this already, but you may want to add. In what ways have your present position prepared you to be fit for the Supreme Court?
Yes, I already answered. 35
Yes.
years is a lot of time to prepare me for the highest court of the country.
Second question, what should the Supreme Court be doing differently and why?
I was thinking of that, Your Honor. And this is just my humble opinion. I do not. I was looking at because in my experience, my lawyers who want to be members of the bar have to take leaves because they have to go to Tagaytay for the pre-judicature program. So at that time, my lawyer did 2 weeks, but then she is already a judge for the MTC. She was previously my lawyer and she was applying for the RTC. And so she had to, after she took the MTC pre-jud, she again had to take pre-jud for the RTC. And she was in Mindanao and the pre-jud was in Tagaytay. So she had to file a leave for 2 weeks. And then she had to rent, she paid to live in Tagaytay, in Vilja, I think, for 2 weeks. And so it takes so much effort to join the judiciary. Maybe it will discourage talent from entering because it's really a bit tedious. I would like to make a suggestion that maybe we do a review of the legal education. maybe the Legal Education Board can do a review, maybe set a track for judicial students who wish to take the judicial route, who want to be members of the judiciary, maybe so that we can do away with the prejudicature. Maybe there could be a track for students who envision themselves to become part of the judiciary, so they can take that track, and thereby we can also, that would also be a judicial economy for the Supreme Court, because I understand it. We have to entail certain expenses for the conduct of these lectures, although they are paid for. That's another thing. Aside from the time and the lodging expense, there's also tuition. So if there could be a review of the curriculum and devise like a track, so that students who wish to join the judiciary can maybe do their studies, and then maybe take an exam as well. But of course, the JBC can also require an examination. But the basic study, the study to enter the judiciary, could be included as part of the curriculum if there are tracks, a special track for the judiciary. And also, there's also a thing about, it also discourages talent from joining the judiciary when I will be candid, my son is abroad taking his JD. He's discouraged because he has to take 1 year study before he can take the bar. So he will have to enroll 1 year. So, but I'm pretty sure that the 1 year study for I think fourth year courses under our present curriculum are all review subjects. So that's could be done away with and just do a review class, because as it is now, you take the 1 year if you're a foreign graduate, and then you review. So it's double. But if you are a foreign graduate and you do away with the requirement of the 1 year enrollment, then you could just go direct to the review portion. So those are my observations.
Yes. Regarding the PJP program, it is mandated by law, the law establishing the Philippine Judicial Academy. The JBC and PILJA are two different entities, but we cooperate with each other through our TWG. We have a representative, they have a representative. And other matters covered by that, they can be addressed to by the legislature, because it was mandated by the legislature, the PJP program. And with respect to the LEB, the students, again, they are not under the judiciary. LEB, the JBC vets the applicants for the position of members of the board of the LEB, but they are under the text. So, ganun.
But for the benefit of the bench and the bar, if we can do a study or a review with respect to those matters, Your Honor.
Yes. Now I go to the questions of Justice Tiham. Question number 1. Would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cyber crimes based on procedural grounds? Explain your answer. If the answer is yes, give examples of procedural grounds which you think are reasonable grounds for acquittal.
There's a valid legal ground for acquitting an accused under the circumstances you mentioned, Your Honor. For instance, there is an information that is invalid, then there is ground to acquit the person because it is his right, it is an accused's right to be informed of the charge against him. And if the information is incomplete, then that would be violative of his right to due process.
Okay. Question number 2. Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently? The stress is on vehemently.
Your Honor, I have no vehement objections, just an observation. There's this case about the libel suit. I dissented in the Court of Appeals, but the main ponentia was affirmed. However, it was strange. I found it curious that the main decision quoted my dissent. So maybe I was happy about that, but it was strange nevertheless.
Happy with the decision. You did not disagree vehemently.
No, Your Honor. I have no right. I'm a mortal. I'm not the god of Paura.
Okay, question number 3. A book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation? Explain your answer.
There are 3 branches of government. In my opinion, it is a reality that money is the one that makes the world go round. And the purse is held by the legislative branch of government. So in that aspect, although theoretically the judiciary has the power to check on the exercise of the authority of the 2 other branches, in reality, it is limited because the purse is held by the legislature. So I do not agree that the judicial branch is the most powerful of the 3. Theoretically, they're all equal, but if you think about it, maybe the one who holds the purse is more powerful.
Number 4. You may answer this if you know. In the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th justice? If you know only.
I'm not aware, Your Honor. I'm
That's
sorry.
So the same question is with respect to the Philippine Supreme Court. There are 15 justices in the Philippine Supreme Court. Who is considered the 16th justice? Explain your answer.
Grabe nga tanong ba?
There were probably many, many number 16s, Your Honor.
Yes.
Because, yes, there is a human factor to it. And of course, the justices, part of the obligation to fealty to the court is to resist the pressures, including the several 16th justices.
Question number 4. What is birthright citizenship? Is there birthright citizenship under the Philippine Constitution? In your opinion, is birthright citizenship constitutional or unconstitutional? Explain your answer.
Birthright citizenship is by blood. So, if a person is has parents, a mother and a father, who are both Filipino citizens, he can opt, and even if he's born abroad, he can opt for Filipino citizenship.
By blood, that means you sanguinis.
Yes, Your Honor.
Not you solely.
No, sir.
Okay. Number 6, is it valid, legal, and ethical for the Supreme Court to reverse, nullify, and overturn the ponencia of a Supreme Court justice upon his retirement or separation from office?
It is, so the decisions of the Supreme Court are part of the legal system, and the legal system is not static. And so, if after the retirement of a certain justice, members of the incumbent members of the Supreme Court, after evaluation and thorough study of a matter, think that it is time to overturn an older decision, then I would think that is a valid exercise of its power.
Question number 7. What is the doctrine of rule of 4 adopted in the U.S. Supreme Court, if you know only?
The United States Supreme Court takes there is a policy of selection of cases that it will entertain, and so they require 4 justices to vote for the acceptance of a particular case.
Question number 8. You are a former court attorney in the Supreme Court. You can easily answer this and the other subsequent questions. During a Supreme Court deliberation, can a member of a division or of the bank insist or dictate how the circulated draft report should be worded or phrased? Can that member who is not the designated ponente demand that an alternative draft he prepared should be adopted instead? In your own words, can you explain briefly what happens during a court deliberation in the Supreme Court?
During deliberations, there is an agenda of cases which lists the cases that would be tackled for that particular deliberation meeting. And then each justice should be prepared to discuss the facts, the issues, and the judgment. Each ponente should be able to discuss. And then the other members of the division, the other 4, should have also studied the case in the agenda, and then they will deliberate on the draft decision, the propriety of draft decisions. In case anybody has objections or maybe suggestions, then it should be taken care of, and then it could be called again for a second deliberation until everybody would agree.
And if there is no agreement?
Then if there's no agreement, then the ponente will release his own ponente, and those who dissent shall write their own dissents.
Or a separate opinion
Or
if
a
they
separate
agree on the conclusion.
Right, yes, sir.
Okay, this positive portion.
Yes, Your Honor.
Okay, number 10. You can easily answer this. Who decides on what items should be included in the court agenda for division, deliberation, or en banc deliberation? Does the Chief Justice have the power to remove an item from the court agenda does the Chief Justice have the power to insist that an item be included in the agenda?
As a general rule, it is the chair. If it's a division, it's the chair. And if it is the en banc, it is the Chief Justice. However, yes, the Chief Justice has the power to take out or to include in the agenda set for deliberation.
Number 11, who disciplines a member of the Supreme Court for any infraction?
Members of the Supreme Court are impeachable officers. Therefore, the disciplining would be by impeachment.
Number 12, are members of the Supreme Court covered by the Code of Judicial Conduct? For violations of the Code of Judicial Conduct, who investigates and who imposes sanctions upon an erring Supreme Court justice? Can Congress investigate and impose sanction upon an erring Supreme Court justice for violations of the Code of Judicial Conduct? Explain your answer.
Wrongdoings by the Supreme Court justices are addressed via impeachment. Congress has no authority to impose any penalties on Supreme Court justices.
Okay, that will be all for the retired justices.
Thank you, Your
I
Honor.
have some questions of my own. I will not cover already those covered by you, and I am adopting the questions of my colleagues. Just a follow-up question on this. You said about 2% were reversed, your decisions were reversed. What were those reversals? Were they on questions of law or questions of fact?
I am not aware, Your Honor, but there were only 4 criminal cases. I'm guessing because they do not write what the titles of the decisions are in the statistics that we received.
Oh, you just asked the statistics, but you have not read why you were reversed?
We are guessing that it's because of the change of policy. The Supreme Court acquitted in the drugs
Just
cases.
change the policy.
I think because before that we were following the jurisprudence. They're very strict.
Yes,
then-
I'm aware of those.
Yes, but now
Change of,
not very strict anymore.
So you
hence
cannot
we
say
got caught in there.
they are questions of law or questions of fact because you have not read them.
We are guessing because the titles of the cases were not indicated, but we were guessing because there's that change in rulings of the Supreme Court with respect to acquittals in drugs cases.
Okay. How do you keep yourself abreast of recent laws and jurisprudence?
I watch. I check on the news, and also I read. I don't read newspapers though, but the news on social media, and so I check on
On the
the
Supreme Court.
yes,
Yes,
on important cases, sir.
Okay, are you aware of recent Supreme Court decisions abandoning earlier established rulings or doctrines? Can you give at least 3?
There is one decision. I can only remember this one. There's a change in the denomination of an illegitimate child. It's not anymore illegitimate. I forget the name, but it's not illegitimate, although there was no change in the law. Well,
You were referring
Justice.
to Aquino versus Aquino,
yes,
marital and
Your Honor, and
the marital children.
there was a point there raised that there's a stigma with a denomination of illegitimate children, so they changed it to marital children. And then what
Okay.
else?
Because you remember that case, Aquino versus Aquino. Is that case a sample of judicial legislation?
I don't think so, Your Honor.
Okay, can you explain your answer?
Judicial legislation would be changing certain laws, but in this case, there was no change in the applicable law. It was just a change in the denomination. So instead of illegitimate, it is now marital. And so I don't think it was,
Marital and non-marital children.
yes, sir.
That is in the rationalization.
Yes, sir.
Yes. And was
We will still,
Article 992 abandoned?
I do not think so, sir. It's just,
This is still the
yes, Your Honor. So if I will come across, if a case comes before me, I would still apply the rule except use a different name for the child,
Yes.
the nomenclature, essentially.
It appears that the Supreme Court literally did not apply 992. What did the Supreme Court write there to
Sorry,
justify its ruling?
I cannot recall, Your Honor. I'm sorry.
Yes, the Supreme Court said the applicable law should be 982 of the Civil Code. Do you remember that? It's 982.
I cannot recall the particular provision, Your Honor.
Yes, because it is in the best interest of the children. So they applied 982. What other cases do you remember which reverse all doctrines? Or one was covered by you earlier, libel.
Yes.
There is a recent ruling by the Supreme Court on prescription. What is the prescriptive period for cyber libel?
I'm not aware, Your Honor.
You're not aware.
Sorry, Your Honor.
The Tolentino Doctrine ruled that the prescriptive period should be 15 years.
1-5. Yes, sir.
Recently, the Supreme Court said it should only be 1 year. Your best guess, what was the reason given by the Supreme Court?
Maybe because cyber is very quick. Online crimes are very fast. So to give it, so in line with that pace, prescription should be shorter.
The Supreme Court said that libel is covered by paragraph 4 of Article 90. Hence, cyber libel of the revised penal code should prescribe in 1 year. Okay. Do you remember the Bukoy case and other cases?
Not familiar, Your Honor.
Oh. Do you know the rulings of the Supreme Court where one spouse sold common property without the consent of the spouse? Earlier rulings of the Supreme Court said that these positions are void for lack of consent.
Yes.
Are you aware of recent Supreme Court rulings?
I'm not aware of any recent Supreme Court ruling with respect to that matter, but I agree that for lack of consent, the sale without the consent of the other spouse is void.
Void.
Yes, Your Honor.
Sold by your husband, it is void. But now the ruling is it is merely voidable.
Voidable.
Oh, can you give a good guess why the Supreme Court changed its ruling? Why it abandoned bukoy?
Now voidable because later the wife can, the other spouse who did not agree can give her consent and then also to be more benevolent to a third party buyer who is a buyer in good faith.
Okay. When is a crime categorized as mala prohibita? And when is it classified as mala in se?
A crime is mala.
What are the differences?
A crime is mala in se if it is if the act complained of is really bad. It is mala prohibita if it is bad only because a certain law defines it to be a crime.
In other words, those covered by special laws are mala prohibita.
Prohibita. Yes, Your Honor.
Okay. How about psychological violence due to failure or inability to provide financial support sufficient to give is it sufficient to give rise to criminal liability?
Sorry, psychological violence.
Yes, due to
Yes, vowsy.
failure or inability to provide financial support.
It could be a covered by the violence against women.
Yes, Bausi.
Vowsy, yes, Your Honor.
Yes. Is it mala prohibita or mala inse?
Malainse.
Malainse.
Mala inse. It is a special law. So
Yes,
it's
but
no
it
longer
is-
special.
Not giving support to your children would be bad in itself. There's an obligation,
So,
I would think.
oh,
It's both. I don't know.
to be liable for
Your lie, it's
Yeah.
bad, but to be for the cause for the liability is the law,
yes.
the criminal liability.
So for you, it is mala inse.
Essentially, the act, yes. However, it as far as criminal liability is concerned, it becomes a crime, and there is liability because there's a violation of the vowsy.
Yes, just because one failed to provide support, liable for vice automatically.
Well, there has to be
What do
proof.
you what should the prosecution prove? Because it is mala inse. What should the prosecution prove?
That there is well the law says that he's under a parent is under obligation to provide support. Number two, there's a failure, and then number two, the parent has the ability to give support, the means. Number three, the child has
Just two.
okay. And so there's a failure,
You recall your
failure,
criminal law.
failure to give support.
Malainse.
Malainse.
Yes.
Just prove the act
And
and the natural law on which it is based.
in Malainse, in Mala Prohibita, you do not prove. You need not prove the intent. But in Malainse, you prove intent. And that is, you prove the actus reus, the act itself, and the mens rea,
Mens
the
rea.
intent.
Grabe nga mga tanong ba? Makadali ng utak. Nahirapan na mag-apply bilang Associate Justice.
You are saved by the bell. This is my last question.
Yes, Your Honor.
Sa red light. Saved by the light, red light. What are the four universal principles of the rule of law?
For universal. I'm sorry, I'm not. I cannot
I
remember.
thought I asked you that before. Pero okay, that will be my last question.
All right, thank you, Your
Thank
Honor.
you very much.
Thank
Your
you.
excuse.
May I be
Not yet.
excused?
Thank you, Justice Mendoza. Your Honors, ladies and gentlemen, we would like to acknowledge the presence of the Honorable Secretary of Justice, Jesus Crispin C. Remulla, ex-officio member of the JBC representing the Executive Department. Secretary Remulla will now propound the questions to our candidate, Court of Appeals Associate Justice Nina Antonio Valenzuela.
I may be repeating something that was discussed already, but I'm really curious. Is there any ruling or doctrine that you would want to visit or revisit if you become a justice of the Supreme Court?
As I already mentioned a while ago, Your Honor. Good morning. As already mentioned a while ago, there was the ruling on libel. I don't know if it has been overturned already, but with regards to publication, the issue, because in the RTC, in the Court of Appeals, I dissented in a suit for libel on the ground that there was no publication. However, the Supreme Court reversed me, and so, but quoted my dissent in the main decision. So I was kind of it was a wonder for me. I was curious why. So I would think that there is probably a necessity to review that. I am not aware if it has been overturned.
How about cyber libel? Would you have any cases of cyber libel that you want to revisit?
None, Your Honor, just the ordinary libel.
Have you ever heard of the doctrine of constructive resignation?
No, Your Honor, I have no idea.
It's a decision penned by Justice Tovide, where President Estrada was deemed to have resigned even without an outward overt act of resignation. Would you agree? Wouldn't you? Don't you think that it's about time that we revisited this ruling?
Of course, that particular decision was, there's probably a political aspect to it. Hence, we should review, yes, Your Honor. And have to be candid.
Ang hirap pala magiging associate. Grabe ang mga tanong.
Why do you want to become a justice of the Supreme Court?
It's every lawyer's dream to reach the zenith, and I think the zenith, the acme, is a position, a job at the Supreme Court. I have been in the service of the judiciary for 35 years now. So it's natural for me to have ambition for the highest position, and maybe I can also hope. I know I can be of service to my country further.
How many years were you engaged in private practice?
Never, Your Honor.
Never. So you took on government jobs
For,
For
from,
from the beginning.
law school, yes, Your Honor.
you were working for the judiciary already from
I
law
was,
school?
yes, Your Honor. My first job was with the Associate Justice Amorfina Melencio Herrera, and then Justice Bidin, and then in the Supreme Court also, and then Justice Guerrero Benaventura in the Court of Appeals, and then down to the MTC.
Don't you think that this will be more of a handicap because you never practiced law and do not know the law from the other side of the table?
Initially, when I was clerking for the Supreme Court the first time, that was my thought, that there was a handicap of sorts because I had known only this one. And then when I went to the MTC, however, I noticed when I went to the MTC already, after you read, because I'm very diligent like that, I read all the TSNs. And so it's like I also was at the hearing. So litigation was essentially not relevant anymore after I read all the TSNs. And also, even if I did not litigate, I taught, which is strange. I taught moot court for decades. So.
What did you teach? What did you teach? What
Moot
subject?
court. Moot court. So I kind of, yes.
But moot court is imaginary court, isn't it?
Right, but we had a judge, we had the adverse counsel on each side, and then we had real facts, etc.
How long were you in the RTC?
5 years, Your Honor.
5 years of the RTC, and then immediately you went to the Court of Appeals?
Yes, I'm running my 15th year in the Court of Appeals, Your Honor. I was 4 years in the MTC, Your Honor. It's been a while.
Di pala basta-basta mag-apply dyan.
Among the justices now in the Supreme Court, who do you admire most?
Do I have to answer that, Your Honor? I do have to answer that?
Please answer.
I think all of them are equally, each their own strengths. So I think I admire them, all of them. And they all are learned, and they come across as very independent-minded. So. And of course, they are there, and so they probably have something that the other lawyers do not have. There's only...
Don't you find your answer corny?
No, it's real. Your Honor, it is true. That's what I think. Because in my life, so this is the way I think all the time. There's only one Michael Jackson. Not everybody's Michael Jackson, because he has talent that not the other guys do not have. There are only 15 justices. They're probably more talented than we are, maybe. So because they're better off. There's only one president, maybe, because he has something that the others do not have, maybe including fate and destiny. So there's something special in a person who is different from everybody else.
What is your judicial philosophy?
It depends, Your Honor. It's a case-to-case basis. As a general rule, I would like to be adherent to the Constitution. So I would be practicing judicial restraint. However, I understand that there are issues, matters that would call for judicial activism. So then I would be more flexible.
Kung ako man ang kinakabahan ng mga tanong nila, uy,
Justice Oliver Wendell Holmes, the U.S. Justice, said that great cases, like hard cases, make bad law. Please elaborate.
ay ginoo ko.
Great cases make bad law.
Like hard cases, great cases, like hard cases.
Hard, like when the issues are of a serious gravity. Is that all right? So hard cases make bad law because there's more chance of error in judgment, in weighing the conflicting interests. So when there are hard cases, a justice has to be more careful and more thorough in the study. Of course, all cases should be studied, but naturally, we all know that there are certain cases that are harder than others. And so these require more effort. Otherwise, then it would be bad law. The decision would be bad law.
Well, when it's a hard case, either which way you decide, there will be a winner and a loser.
All the time, that's the dilemma of it.
And sometimes it's not anymore the law that matters,
True.
but the persuasion that you have in your mind.
Well, that is the one difficult part of being a judge because your hands are tied. You have certain beliefs and but you only decide the case on the basis of the evidence as well and the law. And it's not very easy to refrain from keeping your beliefs aside. That's, I think, one of the more difficult portions of being a member of the judiciary.
What was the hardest decision you ever pen? What's the hardest decision that you ever write?
Red or pen?
Right,
Right.
or pen.
All right. Actually, all decisions are hard. What makes them harder is the human factor that comes with it. So as I already mentioned, there are cases where there are many pressures. Everybody went to law school and knows how to attack a particular case and how to write a decision. But when there are external factors, I call them the human factors, that's what makes it hard. So those are the cases. Do I need to mention which one? But there are several that make it difficult because
Like a criminal case, one of the criminal cases you decided or you wrote.
That one. But it was not pressure that caused my dilemma. It was when I saw I sentenced them to perpetua, and they were a whole bunch, and that's the dilemma also of a judge. Although these persons, you convict them, they have families who did not err. So there were wives and children crying in the courtroom, and every time I promulgate a decision, that's what is heavy on me when I know it's not just the convicted person, it's the entire family.
What crime was committed when you sentenced these people in perpetua?
Kidnapping.
Ang Mahirap pala mag-apply ng Associate Justice.
Okay, I'm done. Thank you.
Thank you, Secretary Remulla. Justice Valenzuela is now, you're now excused. Thank you,
May I be
Justice.
excused, Your Honors? Thank you for the time.
Grabe talaga.
Your Honors, the next candidate to be interviewed this morning is the Honorable Court of Appeals Associate Justice Ramon Bato Jr. Good morning, Justice Bato.
Morning.
The first to interview Justice Bato is the Honorable Secretary of Justice. Oh, no, not yet. Okay po. The first to interview Justice Bato is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good morning, Justice Bato.
Good morning, Your Honor.
You have been with the Court of Appeals for 21 years,
Yes, Your Honor.
and then with the RTC for 7 years, and
Yes.
MTC 5 years.
Yes, Your Honor.
You're very happy about it. Can you share a significant case or legal decision that had a profound impact on you?
Well, the decision I rendered involving then Senator Panfilo Lacson. Because
RTC,
no,
RCA,
for the Court of Appeals,
Court
Your
of
Honor.
Appeals. Yes. Why did it have an impact on you? Is it
Because that shows the independence of the court in deciding that case, because the parties involved there, it involves even the office of the president, who is primarily interested in that case, Your Honor.
This is the Dacer Corbito double murder case?
Yes, Your Honor.
I see.
And how did you resolve the case?
Well, I decided, after going over the records of the case, it is my humble opinion that probable cause was not established from the evidence on record, Your Honor. Because there you have the conflicting affidavits executed by then Colonel Mancao. So he executed three different affidavits. In two of his affidavits he did not directly implicate Senator Lacson as involved in the crime, Your Honor. When he was asked by then the presidential security officer, a general, Prestosa, Your Honor, that his family would be provided with protection in Singapore, it decided to pinpoint then Senator Lacson as responsible for that crime, Your Honor.
How long did it take you to resolve the case?
I think it was decided within the period, Your Honor, allowed, that is within the period of 1 year.
For the Court of Appeals?
Yes, Your Honor.
Yes. What about so this is in relation to this case. Was there any challenging ethical dilemma that you went through while you were hearing this case, while you were handling this case?
Well, not really, Your Honor, but then the independence of the judiciary is being asserted, because we know for a fact that the senator is perceived as as an enemy of the administration, because he was involved. He was investigating certain anomalies committed in the purchase of helicopters by the armed forces of the Philippines.
Whose time was this? Whose term?
The time of then President
GMA?
Gloria Macapagal Arroyo.
Did anyone approach you about the case?
No, Your Honor. The President Arroyo was also responsible for my appointment or promotion to the Supreme Court. So there is a dilemma there, Your Honor.
Are you part of any committee in the Court of Appeals?
Well, I'm the chairperson of the Transportation and LTO matters, Your Honor.
Any innovations, improvements that you have achieved?
Well, the matter, Your Honor, is more routinary when there is available resources for the purchase of vehicles for the court, for specifically for justices. Then, if there is a budget, then we have to go through the process of recommending the purchase of vehicles.
This is the only committee you have handled so far in your years with the Court of Appeals?
Yes, Your Honor, because that is the only committee that was assigned to me by the presiding justices.
All the time. It's the
Yes,
same,
Your
because I
Honor.
remember the last time we interviewed you, you were also handling the same committee.
Yes, Your
I
Honor.
see. Did you have a choice? Could you ask for other committees, or
Well-
it all depends on the presiding justice?
I on orally that I'm interested in the Rules Committee.
Oh,
But then it was not given to me, Your Honor.
it was not granted.
Yes.
How long ago was this?
Well, during the time of presiding justice Mitz Fernando.
Uh-huh. So until now, you are with the Transportation Committee.
Yes, Your Honor.
What would be your significant achievements and experiences which you feel highly qualifies you for appointment to the Supreme Court?
Well, my 34 years of service, continuous, dedicated service in the judiciary, Your Honor. 13 years in the trial court and 21 years in the Court of Appeals.
How about the decisions that you have rendered in the Court of Appeals? What is the batting average of affirmance or reversal?
Well, out of for a 5-year period, Your Honor, that is from March 1, 2020 to the present, I think only 6 cases were reversed
By
out
the
of the
Supreme Court.
200 cases that was elevated to the Supreme Court.
Only how many? 6?
6 cases.
Any
Your-
landmark case?
Well, the case involving the Lemon Law, Your Honor,
Uh-huh.
the purchase of vehicles, brand new vehicles. The case involves a private individual who purchased a vehicle with Toyota. There was some problem.
Lemon law?
Yes, Lemon Law.
Yes.
So,
Is this in relation with the recent decision of the Supreme Court?
yes, the case
I see.
of Department of Trade and Industry versus Toyota Balintawak, Your Honor.
And your decision was?
My decision is to the effect that the Lemon Law should be applied.
Yes.
Why?
Instead of the
Because,
Consumer Protection Act.
Yes, because there is a irreconcilable difference between the general law, that is the Consumers Act, and the Lemon Law, which is specifically applied to the purchase of brand new vehicles.
And how did the Supreme Court rule?
Unfortunately, the Supreme Court said that the consumer can choose.
Right. So you were reversed?
I was reversed, but then, although I was reversed, the petition was also dismissed.
Oh,
Why? I said the Supreme Court said that the consumer can choose,
right.
but then because the consumer did not elevate the case to the Supreme Court, the Office of the Solicitor General has no legal personality to elevate the matter to the Supreme Court.
All right.
When in fact, I also, in that case, I deleted the award of fine that was imposed by the DTI. The court also considered the case moot and academic because the consumer was satisfied when it was repaired by by Toyota. Initially, he refused, but then later, during the pendency of the case, he submitted the vehicle for repair. And it was repaired, and he no longer elevated the case to the Supreme Court. And yet, the Supreme Court said that the consumer has the right to choose.
Right. Justice Bato, you took an exam, a written exam,
Yes, Your Honor.
and it it is in handwritten form. May I know if you are computer literate?
Well, I am not
Adept.
fully
Uh-huh.
literate, but
I
I
see.
can perhaps be trained because I'm using the laptop in the preparation of my
Yes.
decision.
Yes.
Only the matter of doing research
Uh-huh.
using the laptop, I have yet to learn.
And correcting or drafts of your lawyers, how do you go about it?
Well, they prepared the draft.
It's
It is
imprinted in hard copy.
inputted, incorporated in my laptop.
Yes.
Then I do the
In the laptop.
in the laptop, Your Honor.
However, in the written exam, you preferred it to be handwritten.
Yes, Your Honor,
see.
because I find it difficult. I'm not yet very adept in using the laptop directly for the preparation. But when I prepare the decision, Your Honor, I use a laptop.
I see.
So the copy paste, the
Yes,
footnote,
you're able to do that.
I am trying to learn the use of laptop in doing research also, Your Honor.
Can you briefly describe your working style as a part of the collegial court?
Well,
How do you monitor cases in your division?
we have a CMIS, Your Honor,
Yes.
in the court. So the cases action are reported, and we also monitor the cases by going over the agenda being circulated and reported to us. And you have there the list of cases submitted for decision and the list of cases submitted for completion. So we also adopt the aging process, Your Honor. So the first cases filed and completed, submitted for this decision, that's the case that we are going to decide.
Would you know the essence of the unavailable child doctrine involving child abuse cases? It's a decision penned by our retiring Associate Justice Lopez.
That's
Not familiar?
I'm sorry, Your Honor, but
It's a 2023 decision. He was planning to observe. Anyway,
Again, Your Honor, was that perhaps I could...
Unavailable child doctrine. Child abuse cases can still be tried even when the child victims are unavailable to testify in court.
because perhaps
Because
it's a crime against the state, so it can be prosecuted even without the testimony of the private offended
And-
party who is a minor, and a
Yes.
minor can be represented by the father, for instance,
And more
or
so,
mother.
can you venture another reason?
Well, we have to extend protection as parents, but Your Honor, the state has to extend
It's
protection.
actually the vulnerability of the children or the child. What is the writ of habeas corpus?
Well, it is a writ directed to produce the body of the accused and to explain or to justify his detention, Your Honor.
Yes. Under what exceptional circumstances may the writ of habeas corpus be availed of as a post-conviction remedy? So there's already a conviction.
Well, when the person is convicted, he serves sentence for more than the penalty imposed, taking into account the good conduct behavior of the accused who is convicted, and
That's
there is a
one.
reduction of the
Yes,
penalty, Your Honor.
That's one. Can you cite any more?
When the law itself is declared unconstitutional, and
Right.
is being convicted, he served the sentence, and there is that subsequent law.
Lastly,
When the law is declared unconstitutional,
yes, that's in the second
when
one.
the judgment is void, Your Honor,
One more. When the court has no jurisdiction to impose the sentence.
in
What,
in that case, Your Honor, the decision is void.
Yes. What is the legal remedy available for a person who has been wrongfully deprived of their liberty due to mistaken identity?
Well, I think he's entitled to save damages, Your Honor.
Legal remedy.
During trial, Your Honor.
Yes, the person is deprived of liberty, but he was arrested due to mistaken identity. What would be the remedy?
Well, he can question the information filed against him, Your Honor. He is not the person. And so he has to be released. And the information filed against him should be
Question.
quashed.
And what, anyway, this is a decision penned by Senior Associate Justice Leonen. Habeas corpus is the proper remedy. Another decision penned by Justice Lopez. May a violation of ordinances and regulations be enough to justify a valid warrantless search and seizure? I'll give you the facts. Mr. R was driving his motorcycle when he entered a one-way street, which is a traffic violation, calling for confiscation of his driver's license. Police officer ordered Mr. R to stop, but instead of stopping, Mr. R continued to drive, so the police officer and his men chased Mr. R, frisked him, and a .38 caliber revolver was recovered from Mr. R, so he was arrested. So may a violation of an ordinance for going through a one-way street be enough to justify a valid warrantless search and seizure?
No, Your Honor.
Reason.
Reason, because he was not committing a crime that would be a basis for the arrest and search. So there must be the violation of a traffic violation would not result to imprisonment.
Yes.
And so there is no basis, reasonable basis to conduct a search and to arrest the person. in that case, there was a search before the arrest. So that is not allowed under, based on that decision of the Honorable Justice, Your Honor.
You have read his decision? This specific decision, or it's based on your stock knowledge?
Well, based on...
Redon versus people.
Yes,
No.
Your Honor, because when we deliberate on a case before, that is one of the reason why we acquitted the accused, because the search was illegal. He was violating a traffic rules that may result to the confiscation of a driver's license, but not the validity of the search and the arrest of the person, because he must be arrested for the commission of the crime. It must be conducted in flagrante delicto, or there is a reasonable basis on the part of the law enforcer to accost, to search, and to arrest a person. And that is not allowed, Your Honor, because
All right.
of the constitutional
Yes.
provision on illegal search
All
and
right.
seizure.
That's correct. I have one more last question, but the red light is on, so I will stop there. Good luck to you, Justice Bato.
Thank you, Your Honor.
Thank you, Justice Uy.
Ang ganda.
Our next interviewer is the Honorable Secretary of Justice, Jesus Crispin Remulla.
Did you ever practice, did you ever go into private practice?
For a very limited period, Your Honor, for 2 years after passing the bar, because after passing the bar, I applied for a position in the Supreme Court as a court attorney, and I was appointed as a court attorney 1 in the office of the chief attorney in the Supreme Court.
So did you serve under any justice directly?
Yes, Your Honor. I was assigned in the office of then Senior Associate Justice, who later became a Chief Justice. That's Pedro Yap, Your Honor.
The time of Corazon Aquino as president?
Yes, Your Honor.
In your long career as a judge or a justice, how do you handle people who go to you to appeal their cases personally?
Well, as a matter of practice, Your Honor, we don't entertain litigants on cases pending before the Court of Appeals.
How about lawyers?
Lawyers, also, Your Honor, so that as much as possible, we avoid a situation. But there are times that you cannot avoid it, Your Honor. So you have to just inform them that you decide the case based on the merits of the case, the facts, the law applicable.
How long have you been staying in Bacoor, Cavite?
Since for quite a period, Your Honor, since I was appointed in 1997 in the RTC up to the present. I was also appointed MTC judge in Imus, Cavite, Your Honor, in 1991.
Do you still go home to Dumaguete?
From time to time, Your Honor, if there are special occasions like we used to celebrate fiesta in the month of September in Dawin, Negros Oriental, and during Christmas and New Year in during Holy Week, Your Honor, we are in Dumaguete and Darwin, Negros Oriental.
So you still have family in Negros Oriental?
My brothers, Your Honor, my brother and sisters are in Negros Oriental.
Any other lawyers in the family?
My wife is a lawyer who is also was appointed, Your Honor, as a RTC judge of Imus Cavite. She used to be an MTC judge of Nobilita Cavite for a period prior to her promotion to the RTC of Imus Cavite.
So you have been a resident of Cavite for more or less 30 years?
Yes, Your Honor. My son also, Your Honor, is a lawyer. My youngest son, I have only two sons. My youngest is a lawyer and he works with me.
Is there any justice of the Supreme Court that you look up to? At least more than the others?
Well, Justice Benjamin Kagiwa, Your Honor.
Why?
Because I have read his decisions and they are really landmark decisions, Your Honor.
For example?
For example, the decision in a case where a government official is suspended by the office of the ombudsman. And in an administrative case, and the matter is elevated to the Court of Appeals. And in the Court of Appeals, we reverse the findings of the ombudsman. The issue is whether our decision nullifying or reversing the suspension or the penalty imposed by the office of the ombudsman is immediately executory. In that decision of Justice Kagiwa, I said that if the decision of the ombudsman is immediately executory, and if that decision is reversed by the Court of Appeals, that decision of the Court of Appeals is also immediately executory.
Isn't that a pattern? Isn't there a pattern that most of these suspensions or dismissals of the ombudsman are overturned by the Court of Appeals?
I don't think so, Your Honor. It's on a case-to-case basis. If there is a ground for the reversal, then we reverse. If not, then we affirm the decision of the ombudsman.
Because I noticed, at least from in the Department of Justice, many of the people under us who were dismissed by the ombudsman are ordered reinstated by the Court of Appeals. Is there any special goings on in the Court of Appeals regarding ombudsman cases?
No,
Or,
Your
or
Honor.
dismissal of government officials?
We have to really consider the facts, Your Honor. If there is a basis, then we decide the case. We reverse the ombudsman. Otherwise, we have to sustain the ombudsman. It's more on the evaluation, Your Honor, of the evidence. Whether the person is administratively liable is established by the required quantum of evidence.
So there is no pattern where the Court of Appeals usually reinstates or reverses the decision of the ombudsman or other agencies which dismiss employees, or the Civil Service Commission.
No, Your Honor.
U.S. Justice Oliver Wendell Holmes cautioned that great cases, like hard cases, make bad law. Please elaborate.
Again, Your Honor, please.
great cases, like hard cases, make bad law?
Well, perhaps on the assumption that these great cases decided are landmark cases. And then because it is a landmark case, then it may be considered as a judicial legislation. And because decisions of the Supreme Court forms part of the legal system, and it's a binding precedent not only to the parties, but also to subsequent cases, then perhaps that's the reason why it may be considered as a bad law, Your Honor.
Are there other cases of Justice Kagiwa that come to mind when asked about your admiration for him?
Yes, Your Honor. The matter of land registration cases, Your Honor. Because it used to be that to prove that the land is alienable and disposable, you have to present evidence on the proclamation itself by the President or the records. And the mere certification of the juridic engineer that the land is alienable and disposable is sufficient in other cases, not sufficient in some cases decided by the Supreme Court. So in that case, in the case decided by Justice Kagiwa, said that, well, what is required now is only the certification of the juridic engineer that it is within or considered as alienable and disposable based on the record in the Department of Environment and Natural Resources. And that, but there has to be a hearing to be conducted, and that juridic engineer must testify. So that the cases that we have decided before applying, the court directed that pending cases should be decided in accordance with that ruling of the Supreme Court, Your Honor.
It has been said that law is what the Supreme Court says it is. Do you agree with it, even if our justices were not elected by the people?
Yes, Your Honor, because it is the duty of the Supreme Court to declare what the law is on a particular subject matter, Your Honor.
What is your judicial philosophy?
I am for the role of law, Your Honor.
Thank you, Secretary Remulla.
Thank you, Your Honor.
Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Marife.
Ang
Good
ganda.
morning, Justice.
Morning, Your Honor.
Okay. So how many times did you apply to become an Associate Justice of the Supreme Court?
Several times, Your Honor. I can no longer count.
Were you shortlisted during those several times?
Unfortunately, not, Your Honor.
Sige, I heard earlier your wife is an RTC judge.
Yes, Your Honor.
Are there decisions of the RTC which are directly appealable to the Supreme Court?
To the Court of Appeals, Your Honor.
There are no RTC decisions that can be directly appealed to the Supreme Court.
When questions of law, pure questions of law, Your Honor, are involved, then the appeal is directly to the Supreme Court, not the Court of Appeals.
There is no question of fact, right?
Yes, Your Honor.
So in other words, Justice, you will only review the decision of your wife when there is a pure question of law?
I don't review, Your Honor, because I don't have appellate jurisdiction over questions of law. And that if it so happened, Your Honor, I would inhibit because I would not be reviewing. It is not proper for me to review or ever to review a decision of the RTC rendered by my wife, Your Honor.
Kidding aside, I was referring to domestic decisions. Okay, Justice, if appointed, what would the stakeholders expect from you?
The proper dispensation and administration of justice, Your Honor.
So, if ever appointed, you will serve for about 3 years or until August 27, 2028.
Yes, Your Honor.
So, what are your plans to maximize that limited period in order to resolve cases raffled to you? So, do you plan to bring your court attorneys right now and EAs? Or are you going to get lawyers of the associate justices of the Supreme Court?
Yes, Your Honor, because in the Court of Appeals, we have only 4 lawyers, and in the Supreme Court, there are about 20 lawyers. So we have to augment the existing lawyers assigned to me or with me in the Court of Appeals.
So how do you plan to maximize? You will be serving about 3 years only. So, and you understand that there will be several cases that will be assigned to you.
So perhaps we can, with the number of lawyers, then, Your Honor, we can really dispose so many cases.
One of your character references is Justice Alameda. And
Yes, Your Honor.
he wrote a decision enlightening the bar and the bench between the distinction in the issuance of writ of amparo and the granting of the privilege of writ of amparo. Can you tell us the difference between the two?
The issuance of the writ of amparo, Your Honor, if is predicated on the ground that the person is in custody and he has to be produced before the court and explain also why, the reason why is continued, he is under detention, Your Honor.
So how about granting the privilege of writ of amparo?
The granting of the writ is, in a way, made after the evaluation of the basis for the issuance. And so, after the evaluation, then you have to issue the writ of amparo to produce.
So the second one would be the privilege.
The privilege is the writ itself, Your Honor.
Okay. Do you think writ of amparo would be appropriate in cases of red tagging?
Well, I think that is more of an appropriate remedy, Your Honor.
What are the grounds for the issuance of the writ of amparo? There are 3. Huh?
When the security and liberty of a person, Your Honor, is in danger.
They threatened, diba? Or they enforce disappearance, extrajudicial killings, or threatening, no? So
Yes,
would
Your Honor.
red tagging be included therein?
Yes, Your Honor, because with that you are being, your security to your person is threatened, Your Honor.
So the Associate Justice, I would like to acknowledge the presence of Associate Justice Mario Lopez, the retiring justice. And he have the power to endorse the candidate. Okay. One of your character references is Justice Garland. He wrote a decision regarding the mandatory referral mechanism to DARAM. Are you familiar with that?
Unfortunately, Your Honor, if my memory would serve me right, if there is a tenancy relation between the parties, then the case should be referred to the DARAP, which has jurisdiction over the subject matter or nature of the action.
So what if the case between the tenant and the landlord would be qualified theft? Should it be referred mandatorily to DARAP before the court can take cognizance of these cases?
Well, in that case, Your Honor, it's a criminal case. And so it is not within the jurisdiction of the DARAP.
You can ask Justice Garland about this ponensya in that case.
Because strictly speaking, Your Honor, a criminal case cannot be taken cognizance by the DARAP so that the evidence there is to be evaluated by the prosecutor and the case is to be filed. Well, having said that, Your Honor, if really the matter is tenancy and the issue of theft is merely a ploy or used by the landowner to harass the tenant, then perhaps that could be taken cognizance by the DARAP, Your Honor.
So in one criminal case involving VAUSI, violence against women and children, particularly psychological violence and economic abuse, the dismissal of the criminal charge by reason of demurrer to evidence, the Supreme Court said that the RTC should not have dismissed the civil aspect, particularly the support. In fact, this is one of the rulings in the Supreme Court which sustained your decision. Ma'am, if you remember that, you were sustained by the Supreme Court in that case. However, in an estafa case, where the dismissal of the criminal aspect by reason of the demurrer to evidence, the Supreme Court said that the civil aspect must likewise be dismissed. So the question would be, well, the VAUSI, by the way, was decided 2023. The estafa case was decided, no, Spouses Wong, if I remember, was decided in 2021. Did the Supreme Court effectively reverse the ruling in that estafa case with this new VAUSI case?
Well, in the first place, Your Honor, if that decision, the subsequent decision, is not a in-bank decision, because if it is a decision of a division in the Supreme Court, then another division might decide involving the same issue that would not result to the abandonment of the previous decision.
But which do you think, Justice, is a much better decision with respect to the demurrer to evidence? Would it, no, well, the judge should also include the dismissal of the civil aspect, or the court can decide on the civil aspect despite the dismissal of the criminal aspect?
As a matter of practice, Your Honor, the judge should conduct a hearing. After the dismissal on the demurrer to evidence, he should conduct a hearing to determine whether there is a civil liability there.
Speaking of civil liability, so what if the accused taxpayer was acquitted of the tax evasion cases? What would happen to the civil liability? Would he still be required to pay the amount owing to the government for his tax evasion?
It depends, Your Honor. I think if there is a pronouncement that there is no tax liability, then there could be no civil liability to pay. It is, or if the civil liability has already prescribed, Your Honor, the government can no longer collect, then there could be no civil liability. Or there is a pronouncement that the accused did not commit the crime charge, there is no tax evasion. So there is no civil liability whatsoever.
Our next question, Justice. Our 1987 Constitution has several economic provisions. So as a future magistrate of the Supreme Court, how will you interpret them? Will you be conservative so as to limit our natural resources to the Filipinos, thereby enabling that provision in the Declaration of Principles and State Policies that national economy should be effectively controlled by the Filipinos? Or will you be more lenient to the liberal in the interpretation of this economic provision so as to help our country sustain its economic growth?
The economic provisions, Your Honor, should also be considered in relation to the present realities of the time.
Correct.
Because the Constitution is a dynamic Constitution, Your Honor. It should also evolve and adjust to the existing condition.
So if there will be equipoise, where will you tilt the scales of justice in favor of the liberal interpretation of this economic provisions, or you will be more strict?
I think, Your Honor, I am more liberal on the economic provisions of the Constitution.
So in one interesting case, it was tagal na justice, no? In a very peculiar instance, the Supreme Court was divided 7-7. No? It is about the declaration of the unconstitutionality of several provisions of the IPRA, the Indigenous People Rights Act. So the Supreme Court there was not able to arrive at a majority decision which would make provisions of this IPRA unconstitutional. So one of the contentions there is that this IPRA violates the Regalian Doctrine because it effectively gives the IPs the right to exploit, develop, and utilize the natural resources that are found in these ancestral lands. So, assuming the case is still pending, which side are you going to take? Would you take the argument that it is violative of this Regalian Doctrine, or are you going to take the side that it is the right is already private in nature? This property is already private in nature by virtue of this acquisitive prescription, the native title bestowed them the right over these properties.
Personally, Your Honor, this native title is quite I would say, it's very, I don't think it's given to the indigenous people. But then, because their ancestry have been there from time immemorial. But then these tribes are nomadic in nature, Your Honor. They travel from one place to another. And these lands are considered by the government as forestal lands. And forestal lands cannot be acquired by individuals. So there is the problem with that naked title, Your Honor, without a certificate of title issued delineating the exact area, the boundaries, and the people who are entitled to that, how could they prove that their ancestors have been there for quite a period of time, from time immemorial? So I think, Your Honor, that issue should be revisited, or the decision of the Supreme Court on the matter should be re-examined.
It can still be re-examined because there is no res judicata, so to speak, because there is no decision on the merits. It was declared not unconstitutional because it failed to muster the required number of votes, 7-7. Ma'am. So your position, it can be revisited. And if so, you are the 15th member, you would vote in favor of sustaining this Regalian doctrine.
Upon Your Honor, I am in favor of revisiting the decision of the Supreme Court and go into the law and the facts and decide the case.
So next question, Justice, what aspect of the SPJI do you want to get yourself involved in? And what programs do you want to improve, if not institutionalize?
Well, digitalization, Your Honor, is really the backbone of that strategic plan. To do away with papers, Your Honor, and to decide the case with speed because of digitalization.
Last question for you, Justice. One of the barometers for global competitiveness is the rule of law index. So, compliance or adherence to the principles of good governance is one key to improve our country's standing, so that we will have a better standing insofar as rule of law index is concerned. So the question would be, what would be your concrete plans, particularly involving the principle of accountability? No? So there are several principles under good governance, and one of which is accountability. So what are your concrete plans, no, to attain this objective in order to elevate the judiciary's standing, or probably the Philippines' standing insofar as the rule of law index is concerned?
Accountability, Your Honor, you have also to be, decisions of the Supreme Court should also be stable, Your Honor. Meaning, we have to be consistent in rendering decision on the same issue, Your Honor.
And how do you plan to do that? Consistency in the...
So perhaps decisions, if there are conflicting decisions, then this has to be decided by the court in bank to come up with a consistent ruling on the matter, Your Honor.
That will be all, Justice. Thank you.
Thank you, Your Honor.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Attorney Marife. Good morning, Justice. We meet again.
Honor.
I represent the the retired justices of the Supreme Court, and we ask them to suggest questions. And I will ask you first the questions from them. From Justice Ascuna, in what ways have your present position prepared you to be fit for the Supreme Court?
Well, my experience, Your Honor, because experience really exposed me to a lot of cases, controversies decided by the second highest court of the land.
Now, question number 2, what should the Supreme Court be doing differently and why?
Well, it should, I think, come up with decisions reconciling conflicting decisions, Your Honor, through an in-bank decision, so that there would be stability and consistency in the decision of the highest court. Otherwise, because if there are conflicting decisions, then we have a problem. The lawyer who would be approached by the client would say that, oh, we have a decision of this court on the matter. So he would accept the case. The judge would, the moment the case is before the judge may adopt one decision against the other. In the Court of Appeals, we have also a problem. What will we apply? And so, to have stability in the decision, then we must, as much as possible, avoid conflicting decisions between divisions, Your Honor.
Okay, thank you. The next question was sent by Justice Brion. Question, is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why? Explain fully.
The Chief Justice is a lawyer, Your Honor, and he is duty-bound to interpret the law and to allocate the boundaries of the three departments of government. Of course, with the participation of the other associate justices of the Supreme Court. So when the Supreme Court says that that is the law, that is the allocation of powers among the three branches of government, or that the executive or the legislative branch of government has committed grave abuse of discretion, Your Honor, then that is an exercise of the power and the duty of the Supreme Court to decide. Although that would not mean that the Supreme Court is above when it nullify a law, it merely performs its judicial function, Your Honor, in accordance with the provision of the Constitution and the separation of powers.
Thank you. That was the last question of Justice Brion. Now we go to the questions of Justice Tiham. Number 1, would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cyber crimes based on procedural grounds? Explain your answer. Explain your answer. If the answer is yes, give examples of procedural grounds which you think are reasonable grounds for acquittal in those cases.
Well, we have the Speedy Trial Act, Your Honor, and which are usually invoked by the accused. It is a technical rule, and if there is inordinate delay, say for a period of 10 years, from the time an investigation is, a preliminary investigation is conducted, then, and there is no justifiable reason for the delay, attributable to the accused, then under recent jurisprudence, the accused is entitled to be acquitted, Your Honor. That is a technicality. of procedure.
Okay. Question number 2. Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with? Vehemently. Vehemently.
The one case, Your Honor, I don't need to mention the case, but then really, this case is, I would say, a decision that departs from other decision of the Supreme Court. And I'm referring to the grant of bail, Your Honor, to a person who was denied bail before the court, before the Sandigang Bayan, to be precise. And there was only a motion to grant bail. There was no summary hearing conducted by the Sandigang Bayan. It was denied. When the case was elevated to the Supreme Court, the Supreme Court said that the accused should be allowed bail. But then how could you fix bail when there is no determination by the trial court of whether the evidence of guilt is strong? And this is a plunder case filed against the accused. So, for humanitarian reason, the court granted bail. So, ordinarily, if it is the RTC who conducts or who is trying the case, and the RTC, without conducting a summary hearing in a case involving a heinous crime, where the penalty would be life imprisonment or reclusion perpetua, then that RTC judge, if he granted the petition for bail, would be dismissed from the judiciary. I have also read a case where a judge, an RTC judge, in a murder case, was sanctioned by the Supreme Court because the clerk of court calendared the case for a petition for bail when the accused who is charged of murder is at large. And because of that, he was sanctioned. Penalty was imposed. So in that particular case, Your Honor, we would be creating a very, I would say, an exceptional case where there was no hearing, determination, or whether the evidence of guilt is strong or not. And yet, when the case was elevated to the Supreme Court, although with due respect to the Supreme Court, Your Honor, it can dispense with the rules on exceptional cases and by applying the rule on pro hac VC, this case is applicable, or this principle or doctrine is applicable only to this particular case. You have also a problem with decisions of a division, Your Honor, of the Supreme Court convicting an accused, and on a, not even a motion for reconsideration, but a mere letter of a lawyer. The case is elevated to the Supreme Court in banc, and the Supreme Court in banc reversed the decision of the of a division. Now, the Supreme Court in banc is not no appellate jurisdiction, Your Honor, because a decision of a division is a decision of the Supreme Court. Another case, Your Honor, you have cases where the decision is already final and executory. There is already an entry of judgment. And yet, through a letter addressed to the Supreme Court reopened the case and decide the case on the merits, reversing the decision of a division. I am referring to the Manoto case, Your Honor, where that case was already final and executory. It was referred to the Court of Appeals, and it so happened that it was after the inhibition of a justice in the Court of Appeals, it was assigned to me to receive evidence to determine whether there is a valid conveyance of a 33-hectare land located in Quezon City. There was already a decision of a division, Your Honor, involving that case. It was referred to us to receive evidence. And we received evidence. We submitted our report and recommendation. And we, in our recommendation, which was adopted by the majority of the Supreme Court, we declared that all the titles, the reconstituted titles of the three parties, contending parties, are null and void, fictitious, and we declared that that 33-hectare land is a prior land, so it is considered as the patrimonial property of the national government.
Thank you for your vehement answers. Question number 3. A book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation? Explain your answer.
I disagree, Your Honor.
Explain your answer. Well,
The judiciary is not a dangerous branch of the government. The judiciary is there to settle actual controversies between parties so that instead of using their hands or putting the law into their hands, litigants go to courts to settle their cases, Your Honor. So, the judiciary performs a very crucial role in the preservation of peace and order in society, Your Honor. Without the judiciary, there can be chaos and disorder, Your Honor.
okay. Question number 4. If you know only, in the U.S. Supreme Court, there are 9 justices. Who is considered as the 10th justice?
The 10th. Well, I would say that perhaps there's a matter of semantics, Your Honor, identifying another person as a third justice, as the 10th justice, because there are only 9 justices in the Supreme Court.
Conscience.
The
The
10th
tenth justice is the conscience.
is as commonly known in the U.S. is the U.S. Solicitor General. Oh. U.S. yun.
You mean the 10th, the Solicitor General,
They consider it.
the Attorney General of the U.S. Supreme Court decides the cases for the...
They are just considered, siguro, maybe for their opinion, for, Question number 5.
10th justice there would be the president because he overrules all the other justices.
No. Number 5. What is the birthright citizenship? Is there birthright citizenship under the Philippine Constitution? In your opinion, is birthright citizenship constitutional or unconstitutional? Explain your answer.
We follow the rule on jus sanguinis, Your Honor, by blood. So if your father or mother is a Filipino, then you are a Filipino.
Other questions are also about the U.S. Supreme Court. So I will bypass them muna. I will ask my own questions. Follow-up questions. You said your judicial philosophy is the rule of law. I think I asked this question before to you. What are the four elements of what are the four universal principles of the rules of
Equality before the law, Your Honor. All persons are created equal before the eyes of the law. Although the law may also allow substantial classification.
four universal principles of the rule of law? Anyway, we will go to other questions. So, are you aware of recent Supreme Court decisions abandoning earlier established rulings or doctrines? Can you give at least three?
Well, one, Your Honor, is on the ruling that Article 48, that is the complex crime, cannot be applied in cases involving reckless imprudence.
What was abandoned there?
It used to be that there are, if you are charged of reckless imprudence, there are so many persons involved there that you can file separate information. Now, he said there is only one crime being committed, that is reckless imprudence resulting to multiple homicide. So you can file only one information. In a decision rendered by Justice Carana, he said that, well, reckless imprudence is not a mode of committing a crime. So the rule on complex crime should only be applied to intentional crimes, not in a case involving reckless imprudence. So the Supreme Court there said that the Garin doctrine should be abandoned. Another case, Your Honor, is involving the decision of the Supreme Court on the authority, the rule-making power of the MMDA, Metropolitan Manila Commission. It used to be that under the previous ruling, the MMDA has no authority to enact or issue rules and regulation involving traffic. You have the so-called ticketing system being adopted by the MMDA. So before they said that the MMDA is only performing an administrative function. But then in that decision penned by Justice Kagiwa, said that that previous ruling is already abandoned. The MMDA has rule-making power. It can implement an e-ticketing system, and it could be empowered also to confiscate driver's license for violation of traffic rules and regulation.
Okay, thank Justice Mario Lopez is here. What is the proper designation of a crime when the elements of both statutory rape and qualified rape are present?
Well, it's a qualified rape of a minor, Your Honor.
You are correct, Justice Lopez. Reach your decisions. Okay, how do you distinguish or classify crimes as mala,
Prohibita.
prohibita? When is a crime categorized as mala prohibita, and when is it
Mala
classified as mala inse?
Mala prohibita, Your Honor, is a crime that is prohibited by law, but then there is no need of criminal intent, Your Honor.
That is what? Mala inse?
Yes, it is prohibited. Like for instance,
Mala or mala prohibita?
mala in se, mala prohibita is prohibited by law,
So-
by the mere act.
Oh. Intent is immaterial.
Intent is immaterial, Your Honor. Mala in se, you have to prove intent.
Okay.
So, you have a case, for instance, in the law on the Social Security Act, where the president of the corporation or officers of the corporation would be criminally liable if they are not going to remit to the
SSS.
SSS the contribution they collected from their employees. So that is mala prohibita.
Prohibita.
Criminal intent is immaterial, Your Honor.
Immaterial. Okay.
But then, even if it is mala
How
mala
about-
prohibita under a decision of the Supreme Court, said that you have to prove that you committed that particular act by beyond reasonable doubt. So, as president,
Okay.
just because you're a president, you are not criminally liable. You have to prove.
Okay. About psychological violence due to marital infidelity. Is it mala inse or mala prohibita?
Mala inse.
Justice Lopez is there. He has the position also.
Well, it would appear now, Your Honor, that to me, although it's mala prohibita, but you have to prove that it is deliberately used by the husband in order to
Is mala
abuse.
inse? So it is mala inse?
I think it's still mala prohibita, yung violence against women, because you have the psychological violence, financial violence use deliberately by the husband.
Okay.
It's prohibited.
How about psychological violence due to inability to provide support or failure to provide support? Is
That
it
must be
mala inse or mala prohibita? That
Well-
is also punishable under the Bausi Act, special law.
well. It must be deliberately resorted to by the husband, Your
So
Honor.
mala inse or mala prohibita?
So there must be in a way, it's really very, I would say, it's a gray area, Your Honor.
The area, but the Supreme Court decided it one way. So, if you are in the Supreme Court, what is your position?
The criminal intent should be,
So, what is your position? Mala inse or mala prohibita?
I think it's mala prohibita, Your Honor,
Mala prohibita.
to be an effective law.
If you are in the Supreme Court, in both cases, you will be dissenting because the Supreme Court ruled mala inse.
But the criminal intent, Your Honor, is, I would say, regardless, but the moment you,
It's all right, Justice. Very close naman ang laban dun. You ask Justice Lopez. Oh. In another case, the ponente is your favorite justice, Justice Kagiwa. He wrote, Valenzuela, dispensing with proof of criminal intent for crimes mala prohibita, where criminal intent is not an element, does not discharge the prosecution's burden of proving beyond reasonable doubt that the prohibited act was done by the accused intentionally. Can you explain that? What is your understanding?
well, it's because of the principle, Your Honor, that the prosecution has the burden of proof
Yes.
to prove that the accused has committed the act that is considered as mala prohibita. Like for instance, in the example, Your Honor, if just because you are the president of a corporation, but the matter of paying the or remitting the contribution to the SSS is performed directly by the another officer of the corporation, like the treasurer, for instance, Your Honor, and you have no participation whatsoever in the act, then even if it is mala prohibita, you should be acquitted because your guilt has not been proven beyond reasonable doubt.
But intent is immaterial in mala prohibita.
Yes, Your Honor, but the act must be established according to the decision of
The act must be
the act. The mere fact that you are a president, you are not liable.
yes, yes,
You must have participated in the commission of the crime.
yes. In mala prohibita, you prove the act.
Yes, Your Honor.
In mala inse, you prove what?
Criminal
Two
intent.
items. That is mens rea. What is the other one which you prove?
Of course, the elements of the crime, Your Honor, you have to prove.
Actus.
Otherwise,
In Valenzuela, this was written. In criminal law, intent to commit a crime is different from intent to perpetrate the act. Can you explain that statement of your favorite justice?
well, intent to commit a crime is an intentional crime, Your Honor.
No, in mala prohibita. This is mala prohibita.
Intent to commit a crime is different from intent to perpetrate.
Yes, that was written in Valenzuela case. In the case which the court considered mala prohibita.
Because a criminal intent is a state of mind, Your Honor, that can only be proven by the acts of the person, Your Honor, or manifested by the acts of the person.
So you also prove mens rea and actus reus. But that is required only in mala inse. You require it also in mala prohibita?
But that's the decision of the highest court, Your Honor.
Yes.
We have to follow.
Okay.
until such time that
You
it
do
would
not-
be
you do
reviewed.
You do not disagree vehemently this time.
Well, I have my reservation, Your Honor, on that decision.
Thank you very much, Justice. You are saved by the light, red light. That will be all. Thank you. Your excuse.
Thank you, Your Honor.
Thank you, Justice Mendoza. Thank you, Court of Appeals, Associate Justice Ramon Bato Jr. Your Honors, the last candidate to be interviewed for the morning batch is the University of the Philippines College of Law Dean Darlene Marie Berberabe. Good afternoon, Dean Berberabe.
Good afternoon.
The first to interview Dean Berberabe is the Honorable Secretary of Justice Jesus Crispin Remulla.
Good afternoon.
Good afternoon, Your Honor.
When I was looking at your records, I noticed that there seemed to be missing a part of a lawyer's life, which is law practice. Did you ever practice, or did you ever go into private practice?
Yes, Your Honor. Right after my graduation in 1999, I became an associate lawyer in a law firm in Quisumbing, Torres. And my practice was labor law. And then right after, I spent around 5 years in the law firm. And then I went in-house counsel. I became the general counsel for Procter & Gamble, a multinational. I spent 6 years in P&G. And then I was about to be sent to Singapore as an expat to handle regional operations, regional legal. And then I was appointed by the President of the Republic of the Philippines to be the Pag-ibig Fund CEO. I include that as part also of practice because the legal department was under the office of the CEO. And we handled also a lot of cases. And I spent over 6 years in Pag-ibig Fund. And apart from that, because teaching is also legal practice, I taught in the University of the Philippines College of Law since 2002 until the present.
You didn't immediately enter law school after your graduation?
No, Your Honor. Okay, let me clarify that. So, in 1988, when I was about to graduate from BA Philosophy, I had the honor of being accepted in the Faculty of Philosophy in UP as the first female philosophy instructor. So it was an all-male, we called it the last bastion of chauvinism in UP. And because of the honor, I was about to already take the entrance exam in UP Law, but I took another year to stay and to give also honor to their acceptance of me. So after a year, I went to law school in UP, but after 2 weeks, Your Honor, I decided to take a leave of absence. And then I enrolled in Masters in Philosophy. And so I went back to the UP College of Law in 1994 when I was about to defend my thesis in my Masters of Law. Masters in Philosophy.
When you were practicing law under Quisumbing Torres, what was your most memorable case?
Your Honor, I couldn't say really memorable because I was just an associate lawyer. So I remember that the clients of Quisumbing Torres were mostly companies with parent companies who are international. And so most of them are very compliant. So in fact, during the during my stay in Kisumbing Torres, most of the legal practice constituted legal advisory only.
So you never appeared in court for a criminal case where you were the defense counsel
No, Your Honor.
or as a prosecutor or private prosecutor?
No, Your Honor.
Don't you think you missed out on something that you should have learned also? In the sense that being a complete lawyer really requires you to get your feet wet in practice.
Yes, Your Honor, you may say that. Litigation really is a very important practice for lawyers. However, also, during the time that I was deliberating as to which practice of law will I specialize in, the litigation lawyers, the life of a litigation lawyer did not really entice me. And I thought that a lawyer could evaluate what are the skill set that they are best in and what would interest also in terms of subject matter. And because of the many options, also being cognizant of the many delays in the court cases. And during that time, also many of my friends who were in litigation were describing the life of a litigator, and I just didn't imagine myself to be that. But I agree with you that it is not part of my experience and expertise, and therefore I would be offering myself here with another set of skills where I chose to be in those areas.
So what are these set of skills? What does it consist of?
Okay. I have a strong background, Your Honor, in philosophy. And for me, philosophy trained me to think clearly, to exercise academic rigor. In fact, in 3 years ago, I enrolled in PhD in philosophy. And part of it is 33 units of coursework, and each subject required research and writing. So I think that the philosophy background will give me or has trained me to think in a particular fashion, always using or putting a value to the depth of thinking or being aware of one's biases, thinking in a logical manner. So that's one, Your Honor. And then another is because my practice allowed me to have experience in the private sector, also in the public sector, and in the academe. So I respectfully offer that, to my mind, is a unique combination which I hope to be the basis of my meaningful contribution if I will be given the honor to be part of the court.
What law subject would you consider to be your strength?
I think that my strength is legal theory, which is philosophy and law. And then I taught labor law, and legal ethics was the subject matter that I was an examiner, a bar examiner of.
Do you have in you any judicial philosophy?
Your Honor, for me, I would always go back to what is enshrined in the Constitution. So for me, the judicial philosophy is I have to stick to what is stated in the Constitution as the role of the judiciary, but always thinking that decisions should be based on text, but also considering that the law does not exist in a vacuum, that it always has context. And I would go back to what is stated in the preamble, that we are all promulgating the Constitution. And what is the purpose? To arrive at a just and humane society under the rule of law and a regime of truth, equality, freedom, love, and peace. So I would always focus on the rule of law and the purpose, which is the purpose and the aspiration, which is to arrive at a just and humane society.
If given the chance to become a justice of the Supreme Court, can you share to us any ruling or doctrine that you eagerly wish to be revisited, changed, or abandoned?
I'm sorry, Your Honor, I am not able to think of a ruling that I wish to be abandoned. I have a lot of thoughts as to what laws have to be changed. But I'm sorry, Your Honor.
Do you believe in the concept of constructive resignation?
Constructive resignation, Your Honor, may I clarify that it means that maybe in the private sector, Your Honor?
It was a Supreme Court ruling where Chief Justice Davide then said that President Estrada had constructively resigned from his office. How would you look at this decision?
Okay. Your Honor, for me, resignation must be clear, express, voluntary, and therefore the concept of a constructive resignation to me is a contradiction in terms.
U.S. Justice Oliver Wendell Holmes Jr. aptly cautioned that great cases, like hard cases, make bad law. Can you elaborate on that?
Your Honor, maybe I would think that this pertains to cases where either the case has exceptional features, so specific, either that or it is a case that has elicited a lot of emotion in the public, that there becomes a pressure on the court to decide in a particular way. So, because in both cases, when the case is so exceptional, it does not fall under the general categories. And then when there is pressure also, maybe there is a tendency then that the rulings will be so narrow that it only applies to cases which are similar to those exceptions and therefore not principle-based. And I think that is what is meant by it makes for bad law. Because when we have law, we want it to be predictable. We want to be able to understand how it will be applied. And in such case, it doesn't obtain.
Do you have any particular justice here or elsewhere whom you consider to be your idol?
Your Honor, maybe not idol, but only because only because I'm not that type that I would really assess singly or in particular certain cases. But I would say that I admire how Justice Claudio Tihanki wrote his dissent during a time that was very challenged for the judiciary. For the more contemporary justices, I would say that Justice Marvic Leonen, good afternoon, Saj. Justice Marvic Leonen's dissent are also very instructive and very clear, very relatable, understandable. And to me, it is a very important role as well of the judiciary to make their decisions relatable by the public, because it will also add to the public trust that is very, very important for the judiciary to have.
That's all. Thank you.
Thank you, Your Honor.
Thank you, Secretary Remulla. We would like to acknowledge the presence of Acting Chief Justice Marvic Leonen.
Good afternoon, Saj.
Our next interviewers, the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good afternoon, Dean
Good afternoon, Your Honor.
Berberabe.
Good afternoon po.
You must be hungry by now.
Medyo po.
Yes. You are a member of the TWG and a co-chair of the Committee on Sustainability and Environmental Concerns under Saj Leonen, who is here from 2024 to the present, as well as a member on review of the Code of Judicial Conduct from 2023 to the present. What innovations have you contributed to these committees?
Okay. For the TWG on the Sustainability Committee, so the UP College of Law was the one who organized a discussion among deans in order to lay a framework for the discussion for the eventual summit that was held. So it was in cooperation. So I'm co-chair with the president of PALS, and as a result of that conference, we submitted a framework by which the summit eventually was held, and it will be a future activity that we are going to have a write shop where we are going to encapsulate in writing all the things that we discussed in the TWG among the deans and also the summit with the other stakeholders. In regard to the Code of Judicial Conduct, the way that our work was distributed was we were assigned canons, and we were assigned to the canon on fidelity. And I could probably say that I provided the philosophical background for fidelity. There was a lot of discussion on whether, because fidelity was a new canon in the Code of Judicial Conduct, and I think that there was an effort that it would mirror the CIPRA. Okay, so we were struggling because the canon that we are reviewing was supposed to be integrity, and under the CIPRA, integrity became an umbrella concept of all the other qualities that are imposed on a lawyer. So we had a lot of discussion on the background of what fidelity is, and I could say that my sharing of the philosophical background on what fidelity means and how we could tie it to the rest of the canons was very helpful for our discussion.
May I know what inspired you to apply for the position of Associate Justice of the Supreme Court, and what unique qualifications or achievements do you possess that would distinguish you from other candidates who have served as Associate Justices in the Court of Appeals in Sandigan Bayan?
What inspired me to apply?
This is your first time to apply?
Yes, Your Honor, it's my first time. So I have been practicing law for 25 years, into my 26th year. I have practiced in the private sector, as I mentioned, and then moved to the public sector, to Pag-ibig Fund, where I distinctly remember when I was about to be appointed by the President Pinoy, and I told the chairman of Pag-ibig Fund, sabi ko po kay VP Binay, "Sir, why are you offering me the Pag-ibig Fund CEO? Wala po akong alam sa housing, wala rin po akong alam sa finance." At sabi po sa akin ni VP Binay, "Ganun ba? Ako rin, walang alam." Sabi ko, medyo patay ang housing program. But I share that respectfully, Your Honor, because as I went from one field or sector to another, sometimes, or in fact frequently, without experience and only armed with the knowledge, I know that I am not corrupt. I know I have integrity. I know I am hardworking. So even if I don't know anything about the subject matter, kukunti lang po ako kumain. So I am not enticed by money. So I thought that with my background in those three sectors, and now as Dean of the UP College of Law, and being involved in many activities and projects of the Supreme Court, I thought, pero naglalakas loob lang po ako talaga, I thought that I could meaningfully contribute to the court with that background.
May I know what field of law is your specialty?
Your Honor, it's legal theory.
Legal theory.
For substantive law, it's labor law and legal ethics.
You were once an examiner in ethics. Who was the chair then?
The chair is the best bar ever po, yung si
Classmate ba?
Saj Leonel.
Oh.
In classmate, hindi po. Classmate?
Not classmate. Yeah. Oo nga naman.
Hindi po.
What was the percentage of the passing grade in legal ethics?
I'm not aware
Many
po.
of your students, no, you corrected their test papers. In your field, legal ethics.
Siguro-
Marami bang nakapasa?
Opo, marami pong nakapasa. Yung
In
po kasi yung
legal
70%. Yes, also
The
in
best
legal
bar
ethics.
ever.
Yes.
Okay. Since our Saj is here, may I ask you a question that he penned? What is the legal remedy available for a person who has been wrongfully deprived of liberty due to mistaken identity?
I would hazard a guess. Maybe it's of mistaken identity. Maybe it's a writ of habeas corpus.
Is the Saj smiling ba? Yes, you are correct. Under what exceptional circumstances may the writ of habeas corpus be availed of as a post-conviction remedy? Convicted na.
Convicted.
Writ of habeas corpus.
Okay, so because I just remember that the grounds for a writ of habeas corpus is when there is unlawful detention. So sorry, Your Honor.
Deprivation of a constitutional right resulting in the restraint of a person, the court has no jurisdiction, and the penalty imposed is excessive. Let me ask you a question penned by Justice Mario Lopez, who is here. What is the essence of unavailable child doctrine in cases involving child abuse?
Okay. Your Honor, I'm not familiar, but
Hazard based on the
the unavailable.
an answer. Yeah.
Yes. So just based on
There's a child abuse
the name-
case.
Okay, so maybe the child is unable to be brought to court for interview.
To be a witness.
Yes, Your Honor.
And what would be the essence? Why is this allowed?
I would think that it should be allowed in order to still administer justice because even if absent, even if unable to testify because of circumstances that are not the fault of the child, still the case has to prosper based on other observable evidence or submittable evidence based on other factors.
Right. What is the writ of amparo?
The writ of amparo is also a remedy for those who are threatened in terms of their life, liberty, and it applies to extrajudicial killings, enforced disappearances.
How about is the writ of amparo the proper remedy against congressional contempt and detention orders? This is the case of Roque versus House of Representatives Quad Committee. Are you familiar with that decision?
I'm not familiar with the decision, but I would think that the writ of amparo is not the proper remedy. According to the administrative matter, the context of the writ of amparo will be the extrajudicial killings and enforced disappearances or torture, which Harry Roque is not.
All right. That's my last question. Good luck to you, Dean.
Thank you, Your Honor.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Good
Thank you,
afternoon, Your
Attorney.
Honor.
Good afternoon, Dean. So how did you prepare for today's interview?
I watched a lot of JBC interviews on YouTube to just give me a sense
feel.
of
The
what
feel.
happens. And then I tried to anticipate as much as I could what could be the possible questions, and then I would read at night before I sleep.
So, if appointed a dean, what would the stakeholders expect from you?
The qualities that are required of an associate justice are competence, integrity, independence, and probity, in which I think for competence, so I would humbly submit my credentials. I graduated with the highest honors when I was in college. I graduated second in my class in law school as a working student. And I had also my one and only child when I was in third year College of Law. And then I finished my master's in philosophy and currently studying my PhD in philosophy. So when I enrolled in my PhD in philosophy, it was really just for the sake of studying. I knew then, or I thought that I wouldn't use it for my career anymore. I enrolled during the pandemic and I had extra time in my hands, and I thought better to read and earn credits for reading rather than doing any other things like watching Netflix. So I share that respectfully to show you that even if I'm turning 57 years old this year, I am still inspired and motivated to learn, and I'm very disciplined and I work hard. So I may lack in other things, but I work hard. In terms of integrity, I would also respectfully share my track record in the public sector, which I would say could be known by those in the at least in the housing sector, and there were also a lot of times that in fact I offered to resign because of certain transactions that I felt were being forced upon me. To me, for a public sector, the twin factors of integrity and excellence are very important. Because during the time of President Pinoy, there were a lot of public servants who had integrity, but because they were so careful, their agency did not practically move. So you have to have, I would say, you have to have both. For probity, I try also to observe high moral standards, both in my professional life and in my personal life. And independence, so even my family, who are in politics, they know that isa po ako sa mahirap kausapin. So I think that those qualifications I have some.
So admittedly, Dean, you haven't worked in the judiciary. So what would be your advantage over other applicants?
I am aware of the principle that promoting from within has its advantages. Okay? Those in the judiciary already know the ins and outs of decision writing. They already know the systems in place. And it also incentivizes those who wish to establish a career, to start early. However, I am also a believer in diversity of perspectives. And that is what I hope to respectfully offer. Okay? Someone who has a background in the academe could offer a diverse perspective. Someone who has a strong background as well in philosophy that could provide the legal theory in its decisions could, I think, be a very good contribution to the discourse among the Supreme Court justices.
In one of the articles, Dean, that was written about you, it was mentioned that you are a natural risk taker. So what do you mean by that? So are we expecting a justice an associate justice who will be a non-conformist jurist that will take our jurisprudence to another stride?
Thank you. Thank you, Your Honor, for that question. I think that the context of it, the natural risk taker is, I've had like short lectures on how to embrace uncertainty. And I was sharing most of my experience in my professional background. Okay, so the perfect example there was leaving the PNG career, which is more predictable, more certain, more quiet, higher in pay. And when I was offered a role in the public sector, knowing full well that it does not have security of tenure, the president could decide to replace me. Not having navigated that field, again, I just try always to be aware of where my strengths are and what my weaknesses are, and just admit the weaknesses. I thought that because I am humble enough to admit which I don't know, and I could ask questions. Because I work hard, I could research. So that was the context of a natural risk taker. So that means that even if I do not clearly see where it is going, I tend to listen to my gut, especially now that I'm more mature. Because for me, wisdom comes from the many experiences that you've had in your life. And that's why I would trust my gut more. Now, with regard to your other question as to what does that entail, I would always stick to the judicial philosophy. Look at the Constitution. Look at the context. And what is the purpose of having law, which is to have a just and humane society.
So I heard earlier you are a professor of labor. So you may be familiar, Dean, with Article 109 of the Labor Code. So it says, every employer or indirect employer shall be responsible with his contractor or subcontractor for any violation of the code. Well, some of the Supreme Court decision says that any violation is confined to wages. Other Supreme Court decision says it's more than wages. It is not confined to wages. So how are you going to view that? That particular provision or clause in Article 109 of the Labor Code?
Well,
I'll give you a situation. Probably, let's say the company subcontracted the janitorial services. Let's say ABC janitorial services. And then this ABC janitorial services severed the employment of janitors who are assigned at this principal. If we're going to construe the labor code, it would, in its broadest sense, that Article 109, it would say that even the principal will be held liable for the illegal dismissal committed by these janitorial services. On the other hand, if you will be limiting the interpretation of this any violation to wages, then this principal will not be held liable for that illegal dismissal.
I think that the Supreme Court decisions which had said that it is limited to wages is being practical in the sense that the other consequences in regard or that are resulting in that illegal dismissal would not really translate into a just result because of the expansive consequences. And so the Supreme Court is just like choosing which could have a more practical effect on labor.
So you would lean towards confining the meaning of this any other violation of the labor code to wages.
Yes, Your Honor.
Okay. So as Dean of the College of Law, UP, you are familiar with the four aspects of or essentials of academic freedom. So what are those four aspects of academic freedom?
Your Honor, according to the Constitution, the academic freedom includes the freedom of academic institutions to choose who will teach, to choose what to teach, how to teach, and to choose the students who they will teach.
So in fact, in one Supreme Court decision, it is said that the power to discipline students, no, is technically embedded in those academic freedoms. No? So the question would be, if that power to impose penalties or discipline to students, what do you think would be the limitation of that power on the part of the schools or institutions?
The limitation would be as long as it does not violate the rule, the rights, the constitutionally provided rights and freedoms of the students.
So if there will be an equipoise, Dean, between the rights of the student, no, to get into the school as against the preservation of the school or the university's right, no, as to who would they want to be enrolled in their school, which right would you uphold?
There will be, Your Honor, I think in any case, there will be a balancing of interest, which the discretion and wisdom is very important. The threshold to violate the constitutionally provided rights and freedoms is very high. So as long as there is no harm or sorry, let me finish my sentence to that the
So bali,
threshold
Dean,
is very high.
Yeah, there is din an equipoise. These two rights, no, when we say equipoise, the evidence are balanced. The rights of the student and the rights of the institution. So which right would you favor in rendering a decision?
Okay, so if it is completely balanced, so I think under the academic institution, academic freedom, then it will be the institution.
Still about academic freedom. So you may be familiar with this case. You're familiar with the Greenpeace case about the genetically modified talong? You're not familiar. So this is how it goes, no, Dean. So we all know that farmers have been pestered by this pest in their vegetation, particularly talong. And thus, no, this is close to your heart, no, the government through UPLB, no, tap the services of UPLB to make a study, no, in the implementation of this genetically modified talong. Well, the Supreme Court said, no, that it cannot be implemented because it violates the right to a healthful and balanced ecology, because it might be detrimental to the health of those consumers taking this genetically modified talong. But another contention hoisted by the UP is it violates the right to academic freedom because it curtails the right, no, of UP to make this as part of their study, of their curriculum. So what is your take on that?
Your Honor, I would say I would agree with the position of UP. So I think the invocation of the right to a healthful and balanced ecology would there is like a magnitude factor that has to be incorporated in the problem in order to invoke it. But this is just this is still a study, and in studies there are like parameters limited in scope in order to arrive at the conclusion of such research. So I would agree with the position of the UP.
Which has more weight for you, the academic freedom, the right to a healthful and balanced ecology, or probably the right of these farmers, no, to generate this kind of genetically modified talong?
Your Honor, it's hard for me to assess without like circumstances or the other factors that should be considered. So again, I would go for as long as the rights and freedoms are not impinged, then the discretion of the academic institution to undertake that study will hold.
So again, in labor, can the Employees Compensation Commission use its revenues, which are needed to meet its current operational expenses and which are placed under state insurance fund, to invest on something?
The fund is dedicated for a specific purpose, and therefore that purpose is the one that should be used for, and not anything else.
Cannot be invested.
Yes, Your Honor.
So I read your draft decision, Dean. So what is your, in connection with that, what is your understanding of this doctrine of purposeful hesitation? Purposeful hesitation. Nag-hesitate ka purposely.
Sorry, Your Honor, it's in relation po
To your
which,
draft decision.
the right,
Yeah, the one that you submitted to us.
the
What is this doctrine of purposeful hesitation? So it says that when there is a political issue, the Supreme Court tends to purposefully hesitate from ruling on it because they do not want to delve into these political issues. And the question now is, why would it not apply to the submitted decision that you gave to us?
Okay. Medyo nakalimutan ko na po yung exam.
It's about the contempt. If you, I recall, it's a contempt. I think there's a Senate investigation citing these witnesses for contempt. No, it was elevated, no, to the Supreme Court. So that was the decision, allegedly in aid of legislation.
Okay. So I think the purposeful hesitation has to do with the political doctrine versus the expanded power to review by the Supreme Court. Okay. So even if the question, I think in that case is it pertains to internal rules of the Senate, and therefore could be apparently a political question and out of reach by the judiciary, by the Supreme Court, under the expanded power to review, it falls under the expanded power to review if there is an allegation that there is grave abuse or lack of or excess or grave abuse of discretion. So it falls under the expanded power by the Supreme Court.
So-
and I think there's a law, there's a Supreme Court case as well that is similar, or that talks about that specific facts of that case.
So that's it, this power of judicial review, expanded power of judicial review. Did it effectively render this doctrine of purposeful hesitation ineffective?
Well, I think that even with the expanded power to review by the Supreme Court, there should still be a certain restraint and hesitation to deal with political questions. So it has to be, it cannot be abused as well. Okay. So I think that the inclusion of that article, Article 8, Section 1, under the Constitution, was in reaction of the abuses in the political department in the previous in a previous administration.
Last question, Dino. One of the barometers for global competitiveness is the rule of law index. You're familiar probably with that, no? Since you're in the policy making. And adherence to the principles of good governance is one key to improve the country's standing. So now the question would be, what are your concrete plans, particularly involving the principle of accountability, no, to attain this objective in order to elevate the Philippines' standing in this rule of law index?
Okay, accountability in the judiciary. Okay.
Yes, Dean. Yes, Dean.
Well, strengthening the Judicial Integrity Board. I think that integrity, apart from strengthening the institutions, is also a daily thing. Every day, every decision, every action, integrity has to be shown so that the public could give its trust. I am very much aware also of the endeavors of the present Supreme Court in making their decisions transparent, relatable. They have podcasts, they have summaries of their cases, which were unheard of previously. Okay? There is a style book that makes the writing simpler. It admonishes complex legalese. So these are towards the right direction. Okay? You are accountable when your decisions are known, when your decisions are clear, when you give the justification and explanation why the decision is so, when the decisions are coherent. So I would also think and suggest, if I may, that every so often there is also a period to step back and check, have a survey of all the decisions that have been made to see the coherence, if they are still supportive of each other or if there is something that needs to be addressed. Another would be when there are erring members of the judiciary, then action should be swift. And again, the perception of the public has also to be addressed, because that is the basis of the trust that the public will put in the judiciary.
Thank you, Dean. Good luck.
Thank you, Your Honor.
Thank you, Attorney Firme. Our last interviewer is the Honorable Justice Jose Catral Mendoza.
Thank you very much, Tony Marley. Good afternoon, Dean.
Good afternoon,
Good afternoon.
Your Honor.
Kaya pa nyo? Konti lang kumain, you heard earlier. I represent the retired justices of the Supreme Court, so they suggested questions. But I will just ask some only. From Justice Ascuna. Number one, in what ways have your present position prepared you to be fit for the Supreme Court? I think you covered this already earlier. You want to add something?
Thank you, Your Honor. Well, my current role as Dean of the College of Law gives me also, or puts me in a unique position. Okay? Because as Dean of the College of Law, it's not only the College of Law that the Dean oversees. It is also the UP Law Center. Now, the UP Law Center is the think tank, the research center, and that gives the Dean of the College of Law a unique position vis-a-vis the other deans of the College of Law. So why? So the UP Law Center is now also engaged in many research and studies to reform law. So there is one that we are in partnership with the Department of Justice with regard to the revision to the revised penal code. There is also a study and research on and suggestions on the amendments to the labor code, and also to the a partnership with the Land Registration Authority to amend also the law that governs our property law. And therefore, when you are in the middle of efforts to influence policy, to influence legislation, to talk to the different branches of the government, also with the Supreme Court, this gives the Dean of the College of Law a unique perspective.
Thank you. Question number two, what should the Supreme Court be doing differently and why?
Okay. Since I am from the academe, I would hope that there will be a continued review of how the bar exams are administered, the value of the bar exams, or the premium that we put into it, because how the bar exams are implemented mostly dictate how the law schools would run their law schools. Okay, the Legal Education Board would also tailor fit their regulations in accordance with the bar. Okay, so Your Honor, that's.
Thank you. The next question is from Justice Brion. Is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why? And explain fully.
Your Honor, may I clarify that the Chief Justice has more?
Is it legally correct to say that our Chief Justice has a more profound influence on law than our President has? Why? And explain fully.
Okay. In terms of law, okay, I think that the executive branch, where the president belongs, and the judiciary, and therefore also the Chief Justice, are co-equal. And I think that in different aspects, one would have more power than the other. In terms of interpretation and application of the law, then I would say that the Supreme Court has more power. In terms of implementing the law, then I would say that the President has.
Thank you. This is from Justice Tiham. Number one, Would you consider acquitting a person accused of heinous crimes, plunder, human trafficking, and cybercrimes based on procedural grounds? Explain your answer.
The right to due process is a concept that is very hard for many people to understand. I think that I would still acquit if there is a violation of due process. And to me, the principle has to be protected and has to be observed because of the possibility of an innocent person that may be punished if there is no due process. Okay.
So, question number 2. Do you agree with all Supreme Court decisions? Explain your answer. What Supreme Court decisions of recent time do you disagree with vehemently?
The one that I think the secretary mentioned a while ago, I was when he asked me a question, I could not come up, but he raised a case, and then I said that yes, I would agree that, or I would disagree with the Supreme Court case.
Thank you. A book author once described the judiciary as the most dangerous branch of government. Do you agree or disagree with that observation? Explain your answer.
I would not agree that it is the most dangerous branch of government. In terms of danger, I think that all the three branches would be vulnerable to such danger, okay? Because any branch who abuses, who exceeds the power that is reposed on it by the Constitution is then exposed or vulnerable to such danger. So it is not a special position for the judiciary.
What is the difference between judicial activism and judicial legislation?
Judicial legislation is when the Supreme Court decision creates or makes a law that is not there. Judicial activism means that there is the law, and when it is applied, and when it is interpreted or applied, and there is ambiguity, the decision is more inclined towards what is just and what is humane.
What is the Iron Curtain rule in succession? Iron Curtain rule in succession.
I'm sorry, Your Honor. I don't remember.
It's covered by the ponencia of our Justice Leonel. It is, maybe I'll change. Are you aware of the case Aquino versus Aquino?
This is the
It covers Article 992 of the Civil Code on succession.
where there is the footnote on the non-marital children.
That is correct. Oh,
Yes, Your Honor.
are you aware? Sige. Is that judicial activism or judicial legislation? He's listening.
Okay. Your Honor, to me, that is judicial activism. Okay. So again, I think there was it's Article 993 that the specific provision is there, and then there is a space for interpretation, and then the good justice also, by the power of a footnote, was able to inject in the jurisprudence a different nomenclature, a different and more appropriate term for non-marital children.
Marital and non-marital children.
Yes.
Okay. What was the article applied, if you know? It was not 992. If you know only,
No, Your
no.
Honor.
It's Article 982.
982.
You said that the UP Law Center, you are studying, revising the revised penal code. What is the difference between mala in se and mala prohibita? When do you classify a crime as mala in se, and when do you classify it as mala prohibita?
A crime is mala in se when it is inherently wrong,
Yes.
like murder, rape. Mala prohibita are those that are violations of a special law.
Is vowsy a special law?
To me, it's mala in se,
Is it a special law?
but it is a special law.
Yes. It is mala in se.
For me, yes, Your Honor.
Yes. About marital, I'll be specific, about psychological violence due to marital infidelity.
If it is mala in se or mala,
Prohibita.
okay. I would think that it's mala prohibitum.
Ala prohibitum. Due to marital infidelity. How about psychological violence due to non-payment of support, or failure to pay support?
Also mala prohibitum, Your Honor.
Okay. The Supreme Court does not agree with you. Okay lang, it's a new case and they are also divided. You can ask Din. Last one because you may be hungry na. In the case of Valenzuela, where the crime was mala prohibita. In mala prohibita, intent is immaterial. You do not prove mens rea, correct?
Correct, Your Honor.
Correct, mala prohibita. But in that case, the court said that you should still prove intent to perpetrate the act. It wrote, in criminal law, intent to commit a crime is different from intent to perpetrate the act. Can you explain this?
Intent to
Intent to commit a crime is different from intent to perpetrate the act.
I could
In that case, it was written, dispensing with proof of criminal intent for crimes mala prohibita, where criminal intent is not an element, does not discharge the prosecution's burden of proving beyond reasonable doubt that the prohibited act was done by the accused intentionally. So, it was written, in criminal law, intent to commit a crime is different from intent to perpetrate the act. What is your understanding of that?
Okay, my understanding is that intent to commit a crime, there is full appreciation of the consequences of one's action. And that constitutes a crime. The other one, the intent to perpetrate an act, is more limited in that there is no full appreciation of the consequences, and it's just limited to that particular act.
Okay, last, what are the four universal principles that govern the rule of law?
Okay. Okay, Your Honor, I'm very inspired to answer this last question. Rule of law would the four general principles would governing the rule of law. Number one is that law is supreme. The supremacy of law. Number two, that equality before the law does not discriminate. Number three, I think it's transparency and accountability, that law should be transparent. And that number four, that law should be just and should be clearly articulated, and that it should be justly applied.
Thank you very much, Dean. That will be all.
Thank you. Thank you
your
very much, Your
excuse.
Honor. Thank you.
Thank you, Justice Mendoza.
Thank you, Your Honors. Thank you very much.
Thank you, Dean Darlene Marie Berberabe. Good luck po. Your Honors, we will now resume the public panel interview of the candidates for the position of Supreme Court Associate Justice Vice Honorable Mario V. Lopez. Present in this afternoon's public panel interview are Honorable Justice Jose Catral Mendoza, JBC Executive Committee Chairperson and regular member representing the retired justices of the Supreme Court. Honorable Attorney Nesauro H. Firme, regular member representing the Academe. And Honorable Justice Erlinda Piñera Uy, regular member representing the Integrated Bar of the Philippines. Your Honors, the candidates to be interviewed this afternoon are Attorney Maria Rosario de Leon Bernardo and Honorable Court of Appeals Associate Justice Carlito B. Calpatura. May we request the candidates to please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview of the JBC? So help you God. Thank you. May we request Attorney Bernardo to please take your seat in the middle and Justice Calpatura to please proceed first to the holding area, sir. Good afternoon, Attorney Bernardo. Your Honors, the first candidate to be interviewed this afternoon is Attorney Maria Rosario de Leon Bernardo. The first to interview Attorney Bernardo is the Honorable Justice Erlinda Piñera Uy.
Thank you, Attorney Cuevas. Good afternoon, Attorney Bernardo.
Good afternoon, Justice Uy.
Yes, have you taken your lunch?
Yes,
Not
Your
yet.
Honor. I took my brunch.
Oh, okay. I have two sets of questions, one from the Secretary of Justice, and I will ask his questions first. Number one, your PDS shows that you have no direct experience as a judge. Given that the Supreme Court is the highest appellate court in the country, how will you bridge this gap in judicial experience? And what specific steps will you take to ensure that your decisions are grounded in sound judicial reasoning?
Thank you for your question, Justice Uy. It is correct that I did not come from, or I'm not coming from the judiciary. I don't have any prior experience in the judiciary. However, Your Honors, I believe that, there are the work of the Justice of the Supreme Court are two types. The justice performs adjudicatory functions as well as administrative functions. Insofar as the adjudicatory functions of the Justice of the Supreme Court is concerned, I believe, Your Honor, that the manner of analyzing legal problems, the tools that we use in our analysis, the legal writing, and the manner by which we form our conclusions based on research and analysis are the same as those that lawyers from the private sector do. So, another thing, Your Honor, is that I personally have been practicing in various courts in the Philippines, from the Metropolitan Trial Courts, the Regional Trial Courts, the Court of Tax Appeals, and the Supreme Court. So I am well versed in analyzing judicial decisions. Last year, I also was I was part of the 8th prejudicature for the appellate courts. I took part in that. And we were also trained to write decisions in the appellate courts. So insofar as the adjudicatory function of the court is concerned, Your Honors, I don't think that there is really a big gap there. When it comes to administrative matters, clearly there may be some catching up on my part. Fortunately, one of the amazing capabilities of lawyers is their ability to quickly grasp legal rules, including administrative rules. And again, because I have been practicing in the courts, the administrative rules are not totally foreign to me. So I undertake, if I will be fortunate enough to be appointed, I undertake to religiously, diligently study the rules so that I can catch up. And if there is any gap to be bridged, then I am prepared, Your Honor, to do what it takes so that I can catch up.
Question number 2. You have represented high-profile clients, including major corporations in tax disputes, and served as a legal consultant. Have you ever encountered situations where your corporate clients asked you to adopt aggressive legal strategies that tested the boundaries of legal ethics? How did you handle such situations, and how would you maintain ethical standards at the Supreme Court?
Thank you for that question, Your Honor. Fortunately for me, over the years, I had been practicing tax law for over 20 years. And I believe that myself personally, and also insofar as Salvador Lenilio Bernardo, the law firm, is concerned, that we have established a reputation of integrity. Our clients, before they came to us, and you have mentioned yourself, Your Honor, that these are big multinational corporations. Because of our reputation, and it is precisely because of that they come to us to seek legal advice. And we all know that these big corporations have adopted good governance rules within their organizations. And so, very seldom, I can say very truthfully, Your Honor, very seldom have we encountered clients who have asked us to perform acts for them which may breach the boundary of legal ethics. Our reputation, and mine personally, I would say, precedes us. And I am very, well, Your Honor, you were also part of the court where I frequently appeared in the past. And I can say, I am not sure if you have ever heard of any situation where we have ever acted inappropriately. And so I did not feel the need, Your Honor, in the past, until now, to do anything to either discourage my clients because they have never asked us.
Question number 3. As a lawyer with extensive experience in corporate law, how will you ensure that your decisions as a Supreme Court Justice prioritize the protection of individual rights and public interests, especially in cases where corporate interests are pitted against the rights of ordinary citizens?
I always go back to what is the constitutional mandate. And our constitution is replete with many provisions affording protection not only to the big interest groups in our society, but more so it affords protection to the marginalized sectors of our society. And I believe that these constitutional provisions or mandates to give special protection to the marginalized sectors of our society should always be my guiding light, guiding principle when deciding cases. We always go back to the Constitution, and then we go back to the laws itself, which are being implemented or which were passed by the legislature. What is the intent of the law? We always go back to that. First of all, what does the law say? On its face, what if it's not clear what the law is? Then we go back to the congressional deliberations. What is the intent of the legislature in passing the law? It is our obligation, our mandate as members of the judiciary to give life to the legal mandate, whether of the law that we seek to implement or interpret, and of course, the relevant constitutional provisions.
Number 4, why do you want to become a justice of the Supreme Court? And what do you think will make the JBC or the President consider you? It says not consider you for the said position, or maybe we turn it around and say consider you for the position.
Your Honor, my application, the timing of my application, and the position that I am applying for, I believe are providential. While the success of my application is by no means assured, I believe that I am exactly where I ought to be at this particular moment in time. So I am here applying for this position. What I bring to the judiciary and to the Supreme Court in particular is a clear vision of a Supreme Court that is transparent and accountable. Transparent in its processes and also in its decision making. And judiciary also, the Supreme Court that is accountable to the public that it serves. And I intend to utilize my experience as a litigator, as an advisory, a legal counsel that provides advisory services. I bring with me my experience and my discipline, and also my sense of integrity to the court. As I said earlier, Your Honor, I am very proud of the reputation that I have built for myself and for the law firm. I have been with that firm for 20 years and I'm very proud of my record. I can stand on that record and I bring that record to the Supreme Court.
If I may refresh the first question, why do you want to become a justice of the Supreme Court? That's because that's also one of my questions. What inspired you to apply for the position?
Your Honors, I believe that there should be diversity in the Supreme Court. A lot of the Supreme Court justices come from the rank and file, they come from the judiciary, most of them. And for me, it's important for a more robust Supreme Court to have diversity. And that is why I chose to apply, Your Honor, because of the experience that I bring to the table as a private practitioner.
Number 5, with your long years of practice of law and now as an applicant for a Supreme Court justice position, can you share to us your judicial philosophy?
Your Honor, first of all, for me, I stick to the letter of the law. It is only when the justices are called to interpret the law that I go into interpretation. So I go by the strict letter of the law. And the main objective should always be to give life to the intent of the legislature in passing it. I do not subscribe to judicial activism. For me, that is not the domain of the judiciary. Now, having said that, and proceeding from what I stated earlier, that our laws are meant to advance certain public interests and primarily to protect the marginalized sectors of society. If there is any room for judicial interpretation, then I will not hesitate to decide the case in favor of affording more protection to the marginalized sectors of our society.
Number 6, do you have a particular justice here or elsewhere whom you consider an idol and why?
Your Honor, my professor in criminal procedure is the sitting Senior Associate Justice of the Supreme Court, Justice Leonen.
He was here earlier.
Oh, I hope he is proud of
He was
me
your professor?
in criminal procedure,
I see.
Your Honor.
And why?
Well, I consider him an intellectual. He's very articulate. He has actually authored a lot of tax cases in the Supreme Court, and so I follow his decisions. And I also believe that he is a man of integrity. I have not heard anything that would, in my opinion, sully his reputation as a Supreme Court Justice.
Number 7, it has been said, law is what the Supreme Court says it to be. Do you agree with it, even if our Supreme Court justices are non-elective officials?
The law is what the law says, Your Honors. If there, as I stated earlier, if there is room for interpretation, then that is only the time when the judiciary will be called upon to decide what is the law or what the law tells us. And actually, if I may quote the Honorable Justice Mendoza in the case of Imbong versus Ochoa, he said in that case that when the judiciary is called upon to adjudicate, then it must interpret the legislation vis-a-vis the most vital principle that binds Philippine society, and that is the supremacy of the Constitution. So again, the power of the judiciary is admittedly very broad. However, it is also limited by what the law says. It cannot go beyond that. And so, when the Supreme Court adjudicates actual cases and controversies brought before it, and decides on it and issues a decision, then that decision is entitled to respect by all the parties concerned, because that is the role that is given to the judiciary in our system of government. It is the final arbiter of all disputes brought before it.
Number 8, if given the chance to become a justice of the Supreme Court, can you share any ruling or doctrine of it that you eagerly wish to be revisited and abandoned?
Perhaps, Your Honor, I will choose an area which is close to my heart, which is taxation. Perhaps the proper word to use is revisit. Revisit rather than overturn. Because I don't think that this issue has been properly ventilated before the Supreme Court. And that is really the power of the Commissioner of Internal Revenue to execute warrants against the properties of taxpayers, even if the subject assessment is not yet final and executory. We must view that issue from the lens of the constitutional provision on due process.
Have you handled cases involving those issues with the tax court?
Yes, Your Honor.
And how did the tax court act on the matter?
It has not been squarely decided upon by the
Supreme Court? Yeah, we're eagerly waiting for that. Number 9, U.S. Justice Oliver Wendell Holmes Jr. aptly cautioned that great cases like hard cases make bad law. Please elaborate.
I'm not sure precisely, Your Honor, what that meant. It may make a bad law, but it can also make great jurists. Because only great minds can decide difficult questions of law. And it is an opportunity for great minds in the Supreme Court, in the judiciary. It is a challenge to them that if there are difficult questions of law brought before them, that they can find a way, they can analyze, use all the tools necessary to analyze the case and come up with the equitable decision. So it's an opportunity. I don't see it, Your Honor, as bad thing. I see it as an opportunity for the jurists to show the great minds that they have.
Last question. The Supreme Court is a collegial court. Decisions are arrived at by majority vote. What if you were confronted with a particular question of law that, if decided one way, will easily get the sweet nod of at least the majority of your fellow justices, but will surely earn the ire of the Filipino people? In deciding that question of law, will you join your colleagues or will you align yourself with the populace? Explain.
I do not believe, Your Honor, that public opinion should influence the court's decision on the cases that the court is handling. The only test should be what, if I were involved in it, what to my mind is the appropriate decision based on my understanding of the law. And based also on what is the intent of the law, what is the objective of the law. The fact that it may cause or result to a public disapproval or uproar should not dominate my my reason for voting one way or another. And especially so in controversial cases. I think that should be expected. That and the decisions of the court are public. If there's any difficult question of law involved and it can be decided either way, I think we can. I believe that we should expect disapproval from one sector or another. So we should not be scared of public disapproval, and that should not be the basis for us to decide the case one way or another.
So that ends the questions of the Secretary of Justice. I have a few questions of my own. Attorney Bernardo, I noticed that in college you took up BA Political Science.
That's correct.
But now, in your practice is in taxation. Why the shift? Or why the choice of taxation? Any special reason?
Your Honor, I have to give credit to my tax law professor, Attorney Recalde, bless her soul. She made the taxation very interesting. And even though I took up political science as my undergraduate course, I was not totally averse to math. So when Attorney Recalde became my professor, and I was actually fascinated by it. And so I would like to volunteer that my lowest grade in the bar examinations is taxation. And that was a great disappointment for me. But however, because it was my favorite subject in law school, then I persevered. It was a challenge, became a challenge to me to excel in this field. And that's why right after taking the bar, passing the bar, I went directly to CSIP Gores and Velayo to become a tax associate.
Do you have any other exposure to other fields of law aside from taxation?
Yes, Your Honor. In fact, especially during the latter part, in the recent years, I have also handled a lot of labor cases. Those are incidental to my retainer agreements with clients. Especially during the pandemic, there were a lot of labor cases that we were asked to handle for our clients. And I also did not handle just, solely tax matters. I handled mergers and acquisitions, contract reviews, mainly corporate cases. So it's not pure taxation, Your Honor. And in fact, if I may mention also, I had the brief brief stint at the Department of Finance. And there I was very fortunate because I gained perspective, in governance, and gave me a deeper understanding of how the law intersects with governance and economic development. In the Department of Finance, I had a lot of experience handling and reviewing public infrastructure projects. I also had experience advocating for the Department of Finance, advocating for laws. So we were frequently also at the legislature defending the bills emanating from the Department of Finance.
So you mentioned labor law. What is required for what is required under procedural due process in dismissal cases?
There are foremost requirement is the two notice rule.
Right.
First, the employee must be informed of the acts complained against him or her, and the employee must be given the chance to explain his or her side. And then the second notice, of course, is the decision that should be given to the employee on the case regarding him or her. And the decision must adequately explain the basis, its basis based on what are the facts, what are the acts committed, complained of, and what is the basis, legal basis for the decision.
Under the Constitution, Article 8, the Supreme Court has the power to promulgate rules concerning the protection and enforcement of constitutional rights. What, in your opinion, are significant rules promulgated for the protection of constitutional rights?
At the top of my head, Your Honor, I can think of the rules on the issuance of the writ of kalikasan, the writ of habeas data, writ of amparo, writ of course, the writ of habeas corpus is in the Constitution.
Can you distinguish these writs?
Well, the writ of kalikasan may be issued by the courts if there is an actual or threatened violation of the constitutional rights of the people to a healthful and balanced ecology.
Yes.
The writ of amparo
Yes.
may be issued by the courts if there is a threatened or actual violation of the people's right to liberty, security, and life. Habeas data also involves people's right to information, protection of the people's.
What more? What else?
Also life, liberty, and right to information, security, and liberty.
Right to privacy
Oh, yes. That is correct,
when
Your
it is
Honor.
violated.
Yes, the right to privacy.
Yes. Is the writ of amparo the proper remedy against congressional contempt and detention orders?
Your
This
Honor,
is the case of Roque versus House of Representatives Quad Committee. How did the Supreme Court rule? Says yes or no?
Your Honor, I'm not familiar with that case, I have to admit.
But to your mind, writ of amparo,
It is, well, there is an actual detention there in that case, so
the scope of writ of amparo is limited to
I'm sorry, Your Honor, that
extra
I'm
killings,
not-
extralegal
extrajudicial
killings, and forced
killings.
disappearances. All right.
Thank you, Your Honor.
What to your mind
are urgent judicial reforms that must be undertaken?
I refer Your Honor to the SPJI, the strategic the I in that document we can see that the court aimed to make access to the courts to make the courts more accessible to the people. In the past few months, I've had the experience of people coming to me for asking me about, you know, what or where, what are their remedies, for example, in cases involving rape, or either as a victim or as an accused. I have also encountered cases involving abandonment by the husband of his family. And simple cases like what are the rights of the employee under a particular contract of employment. What I noticed in these instances, Your Honor, is that the people involved do not know where they can seek legal advice and legal remedies. So, to my mind, it is very important the project of the Supreme Court to make the legal system more accessible, especially to the underprivileged sectors of our society. That is one thing that we should really push for, accessibility of the courts. And if we read the SPJI, the court has actually a lot of programs in line to address that. And I hope that these programs will be implemented soon.
All right, my last question. Under the rules on electronic notarization, may the electronic notary public be allowed to perform any electronic notarial acts for a principal located outside the Philippines?
I am not aware of the actual answer to that question.
You have not read this
I have not,
rule?
That particular rule which addresses your question, Your Honor.
The electronic
The
notary
electronic-
public is here and the
Yeah.
principal is abroad.
For me, it goes into the issue of jurisdiction. Because
Under the rule, what is stated there? Is it allowed now or not allowed?
I believe, Your Honor, it's still not allowed. The affiant must still be in the Philippines.
Actually, it is now allowed
Okay.
for as long as the principal is within the premises of any of the embassies of the Philippines. So that's my
correct,
last
Your Honor.
question.
The embassy. Yes.
Good luck to you, Attorney Bernardo.
Thank you, Your Honor.
Thank you, Justice Uy. Our next interviewer is the Honorable Attorney Nesauro H. Firme.
Thank you, Attorney Marife. Good afternoon, Attorney.
Good afternoon, Your Honor.
So how did you prepare for today's interview?
Aside from a lot of prayers,
I understand this is your first time to apply to any judicial post.
yes, that is
So
correct,
why
Your
did you
Honor.
not opt to apply to become an Associate Justice of the CTA or the Court of Appeals for that matter?
Those were certainly options that I considered. I stated earlier that the timing of my application, as well as the position that I applied for, are providential for me. Took a long time for me to discern whether I should actually apply at all. But however, I've spent also many years deciding whether at a certain point in my career I should transition from private practice to government service. I enjoyed very much my stint at the Department of Finance, and if not for the fact that my husband asked me to leave public service, I would have stayed. And in the course of my practice, I realized that what I really want to do is to do research work, analysis, and legal writing. So if there will be an opportunity in the future for me to apply also for other positions in the judiciary as an appellate court justice, whether the Court of Tax Appeals, Court of Appeals, or Sandigan Bayan, then I would surely consider that, Your Honor.
So if appointed attorney, what would the stakeholders expect from you?
They should expect transparency in my decision making. I will all push for transparency also in the court processes. Efficiency and judicious decision making. Impartiality, first and foremost. Those are the things, Your Honor, that I believe the public can expect from me as a justice.
So you were former law partner at Salvador Leonilio Bernardo Law Firm.
That's correct.
So
Your
why did you leave it and establish your own law office?
As I mentioned earlier, took a long time for me to discern. Many years, in fact. It is all part of my plan that at a certain point in my career, I should transition to public service. And I've been with the law firm for more than 20 years. I started as a senior associate in 2001. I was promoted to partner in 2007. I became a name partner in 2015 and managing partner in 2019. So to my mind, I have already achieved what I sought to achieve in the law firm. And it's time for me to maybe leave my comfort zone, do greater things. Do things that will affect more people. And I can do that, I believe, if I were part of the judiciary.
I'm sorry, attorney. The question is, why did you leave the office and establish your own law office?
Yes, Your Honor. Well, this is a transition because, I have to continue working while planning for my future in the judiciary. But also, if I may continue what I was saying earlier, Your Honor, another option that I was considering when I left the law firm was to concentrate on or to join a startup law firm where I can contribute to the development of the knowledge database, so knowledge management of the law firm. I would like to apply what I learned in Salvador Leonilio Bernardo. It's a challenge because I know that appointment in the judiciary is not by no means assured. And so that is also my plan. If I will not be fortunate, then I shall pursue that plan of mine to join a small startup law firm.
Thank you. In your letter, attorney, you mentioned that you won innumerable tax cases, even up to the Supreme Court. So can you cite or name probably at least 2 cases of doctrinal implications?
I am proud, Your Honor, to say that I am the counsel of record of Deutsche Bank Philippine branch versus Commissioner of Internal Revenue. This case actually was decided by the Court of Tax Appeals in Division and Bank against the taxpayer. and it involved it's a refund case where the taxpayer paid 15%, and afterwards, realizing its mistake, the taxpayer applied for a tax treaty relief ruling with the Bureau of Internal Revenue. However, that filing was beyond the 20-day period mandated under the administrative rules of the BIR. And so, expectedly, the BIR denied the claim for refund, so we appealed to the Court of Tax Appeals, and the CTA ruled against us, stating that we did not comply with the 20-day prior application period. And so we went to the Supreme Court, and the Supreme Court reversed the decision of the Court of Tax Appeals. A very important pronouncement by the court is that number one, the administrative rules do not take precedence over our international obligations over the under the tax treaties. And so it is important that the court gives life to the mandate of the international tax treaties to give relief to the taxpayer, and non-compliance with the administrative rules do not defeat the right of the taxpayer, or does not defeat the right of the taxpayer to the preferential rate under the treaty. And more importantly, Your Honor, that's the first time that the Supreme Court stated that tax treaty relief rulings do not confer rights upon taxpayers. They only confirm the status of the taxpayer, whether or not he or she or it is entitled to the tax treaty relief. So it's just confirmatory rather than conferring any rights on the taxpayer. And another case, Your Honor, just recently in 2024, this is not really a decision of the Supreme Court, but I'm proud of this case because this case involved Kuehne+Nagel Philippines versus Commissioner of Internal Revenue. I was also the tax counsel for that in that case. It was an assessment case. We won on the basis of the BIR's failure to comply with procedural due process. But more importantly, what I like about this case is that even though we did not ask the court to refund the tax that the taxpayer paid to the BIR, the court, motu proprio, ordered the refund of the tax paid. Because what happened here was that there was an assessment, the taxpayer made a partial payment of the assessment, but when we went to court, the court held the assessment to be null and void. But there was no prayer on our part to refund. But the court ordered the refund. And the pronouncement of the court in that case is that even though the issue was not squarely raised before it, it should follow as a matter of expediency that the court should also order the refund of the tax paid, because no valid tax payment cannot proceed from a void assessment. And it was impractical on the part of the BIR and the court to require the taxpayer to file a refund case only after a decision has been made already that the assessment was null and void.
So it was the CTA. You mentioned it is not with the Supreme Court.
With the Supreme Court.
Yeah. So it could still be appealed.
It could still be. It is a subject of appeal, Your Honor.
Yeah. Okay. So admittedly, attorney, you haven't worked in the judiciary. So my question now is, to what extent do you agree with the concept of judicial careerism?
Can I ask Your Honor for clarification what by judicial charism?
So what is judicial charism? Based on your understanding, attorney?
It's charism or
Careerism.
careerism. Is that spending or beginning our career with the judiciary, spending a lot of years there? It certainly helps, Your Honor. And in fact,
I mean, to what extent do you agree with that? Because understandably, you will be an applicant coming, well, an outsider, so to speak, and you will be pitting against applicants who are already within the judiciary. So to what extent do you agree with that concept, with that rule?
I mentioned earlier, Your Honor, that there are advantages and disadvantages to coming or for a person coming from the judiciary or spending a lot of or a major part of his career in the judiciary. But however, I also believe that spending so many years in the judiciary that does not necessarily give the applicant an advantage over the others who come from the private sector insofar as adjudicatory functions of the court are concerned. It's the same, we use the same analytical tools, we use the same, we research the same materials, we use the same materials for research. The judges write decisions, resolutions, orders. Private practitioners write pleadings. We are both engaged in advocacy in a way. So there should not be an undue advantage given to the members of judiciary or career jurists. But I do acknowledge that they may have some advantage insofar as the knowledge of administrative or internal rules are concerned. And that is certainly something that should spur applicants from the private sector to work hard on.
The Supreme Court has repeatedly mentioned that justices and judges must possess this virtue of gravitas. So what is your understanding of that, and how would you display that virtue?
For me, gravitas is earned. It's not something that is innate in a person. And how does a jurist, a justice, earn it? Through the decisions that he makes, that he issues, through the decisions through his decisions in difficult cases. So you earn the reputation of being an intellectual. Then people respect you for your capacity to decide difficult cases. Not just difficult cases, but even the simple cases. If you have the ability to become to show impartial, come up with impartial decisions, if you are able to dispense justice, then you earn the gravitas. You build your own gravitas. It's earned. It's not innate in a person, I believe.
So I was looking at your profile, attorney. So it says that you work at the Revenue Operations Group directly under the former Undersecretary Gison, and later at the Office of the Secretary of Finance under former Secretary Camacho, where you were involved in the review of government infrastructure contracts, sovereign loan agreements, and was a member, in fact, of the Philippine negotiating team for the RPR Germany and the MECO Taiwan double taxation agreement. And also heard earlier, you mentioned about international obligations. So I would assume that you are familiar with international law.
A little bit, Your Honor.
Okay. So the first question would be, is the Philippines a monist or a dualist?
I'm not familiar with those terms, Your Honor. If I may ask for clarification.
So it pertains to how we consider international laws as part of the law of the land.
Well, at the top of my head, there is Republic Act 9871, and that law specifically states that we adopt the international laws on international humanitarian law as part of the law of the land. So in that sense, then, and especially so when international law contains customary norms, then we do consider these laws as part of the law of the land. In fact, in our Constitution, there is such mandate.
Yes, I was about to ask you about that, the doctrine of
The
incorporation.
doctrine of incorporation.
Okay, now the question is, there are several cases decided by the Supreme Court which would tell us or lean towards that there is no, in fact, in the case of Secretary of Justice versus Lantion, it is said that the rules of international law form part of the law of the land and no further legislation or legislative action is needed to make such rules applicable in the domestic sphere. And in another case, Tanyada versus Angara, it is said that, however, while sovereignty has traditionally been deemed absolute and all-encompassing on domestic level. So the question is, you know that this as a future or potential Associate Justice of the Supreme Court, the Supreme Court has the power to rule on the validity or invalidity of international agreements. So how are you going to reconcile these pronouncements wherein it is said that it is all-encompassing on domestic level and that no further legislative action is needed to make these international laws applicable to the law of the land?
First of all, Your Honor, if we are a party to a treaty, then we have an obligation to comply with our obligations under the treaty. And there is no need for domestic law to make that treaty operable. We can see that clearly, for example, in the international tax treaties, and before we disengage from the Rome Statute, even before the enactment of RA 9871, when we acceded to the Rome Statute, then it's already part of our law. It's self-operative. And it is consistent with, I believe, the theory of self-limitation, or it's auto-limitation, I'm sorry, where the state consents or agrees to limit its own powers and agrees to submit itself to international law by virtue of us being a party to international tax treaties.
But attorney, does it not trivialize the power of the Supreme Court to declare these treaties unconstitutional? Kasi you said that it should already be part of the law of the land. Diba? Does it not trivialize that the Supreme Court can still, despite that it's already part of the law of the land, it can still invalidate these treatises, these international agreements, as you mentioned?
Again, Your Honor, if we go by the principle of auto-limitation, then we consider all of these international norms, all of our treaty obligations as part of the law of the land. But however, we cannot deny the power of the court to exercise its power of judicial review. It has the power by virtue of our Constitution, it has the power to exercise that judicial review in instances or in cases properly brought before it. If, for example, the court finds that certain international obligations conflict with our domestic law, then within the sphere of our jurisdiction, for as long as the court is acting within its power as prescribed in the Constitution, within our jurisdiction, then we ought to respect the decision of the court. It is, after all, a final arbiter of what constitutes the law of the land, and especially so when that international treaty obligation is sought to be implemented here. It is the Supreme Court that has the final say whether or not that law is valid, or whether, for example, it can also be invalidated due to non-observance of procedural rules. So, within the sphere of the Supreme Court's jurisdiction, then I do not see how that conflicts with our international obligation, or with first of all, if the court decides, for example, that a certain international obligation does not conform with the Constitution, then it's certainly within the purview of the court to do that.
Okay, I also heard earlier, actually this is not a part of the question, but you said you had a practice about in labor laws. Yeah, I heard that earlier. So what is your understanding of garden leave?
I did not reach that.
It's about retrenchment. So what do you do when you are retrenched? You do nothing, di ba? You go to the garden and still you get paid. Yeah, that's the garden leave. Okay, because there is a 30-day notice, di ba?
Yes,
Before
yes,
the
that's right.
retrenchment or the
Before
termination of services will be
take effect.
effective. So within that period, 30 days, you call that garden leave. You still get paid despite not coming to work.
Well, Your Honor, if a person is retrenched or separated from the service by virtue of retrenchment, then I suppose the employee deserves
Garden leave.
garden.
It's from the concept that you do nothing but to go to your garden. Okay. At any rate, no, I read your decision, yung what you call it, draft decision you submitted to the JBC. It's about the legislative inquiry in aid of legislation wherein the resource person or witnesses were cited in contempt. So the question now is, why do you think the concept or the rule on purposeful hesitation was not applied in that one?
Specifically, Your Honor, in the case of it's a case involving it's a decided case by the Supreme Court,
Yeah.
or are you talking about
Both.
the decision
I
that
think you
drafted?
cited in your written
Ah, okay.
decision the one cited by the Supreme Court. Well, the question is, why did the Supreme Court did not hesitate, no? Or probably, sorry, why did they still rule on the matter despite of its political implication? It
Well-
could have purposely hesitated
or
from doing so.
deferred to the legislature.
Yeah, we call that the doctrine of
Yes.
purposeful hesitation. So why did they not apply that doctrine in that case?
Well, the court in that case decided on the basis of whether or not the legislature followed the rules. I think in that case. So I'm trying to gather my thoughts, Your Honor. if there is a clear violation of the rules or violation of the constitutional right of the party in that case, which was a subject matter of a legislative inquiry, then again, the court should not hesitate to